Mr. R.D., the learned counsel appearing for the petitioner. Also heard Mr. S.K. Talukdar, the learned counsel appearing for
Co-person department.
the corporation, standing counsel for corporation department. Mr. Day submits that he would like to file an affidavit in reply to the affidavit in opposition filed by the respondents. Raised for 2 weeks' time. Later matter will be listed after 2 weeks for admission hearing. For admission hearing.
No.
We'll keep it as admission hearing. We'll
Yes,
still, if you
yes,
file it, then
yes,
we'll.
My lord, it's a 2019 matter.
Hmm.
Date may be fixed, my lord.
Preferably on a hearing, so that it can be disposed of.
Later matter will be listed on 12th of May.
My lordship. Obliged. Look, the judgment, yesterday's case I have. my lord.
You have given.
Well.
May I please?
May I please, your lordship? I request for a short passover. My senior is on his legs in court number 1, your lordship.
Who is your senior?
B. Sharma, your lordship.
Why not may kindly fix the next day? If that is senior of my friend is busy, why not may kindly fix this case on next week, because I have too many matters to get by. On next week, on next week, my lord.
Okay, on the prayer of parties are duly represented on the prayer of the on the joint prayer of the parties. Let the matter be listed after 2 weeks.
But the date may kindly be fixed.
No,
because
after
the
2
matter-
weeks. After 2 weeks. Yeah.
but
After
the
2
date may
weeks.
be fixed.
No, after 2 weeks. Not only all matters.
Lordship, in this case, though the council is not present.
Yes.
Petitioner, but Lordship, we have been directed to obtain instructions.
Hmm.
And Lordship, may I pray for some more days, Lordship? We have not yet received any instructions, Lordship.
Okay, none appear for, you are appearing?
Item five. Okay. Yes, Lordship. Lordship,
Okay, I heard Mr.
N.
He's asking for some time for instructions. Heard Mr. N. Ahmed, the learned counsel.
Ali.
Huh?
N. Ali.
N. Ali, the learned counsel for the petitioner. Also heard Mr. H. Sharma, the learned edition senior government advocate for
2, 3,
For
and 4.
2, 3, and 4. MSN Bordelev, learned standing counsel for respondent number 1. Mr. Sharma submits that Mr. Sharma prays for some time to complete his instructions. Let the matter be listed after 2 weeks. 2 weeks, Mr. Sharma,
Let it be 3 weeks, Lordship.
after 3 weeks.
Please, your lordship. Lordship, in item 7 and 8, we have filed our reply affidavits, lordship. The affidavit in item 7 will cover the matter in item 6, lordship. So I kindly pray that the matters be admitted and fixed for hearing in the usual course. We are on interim bench.
Heard Mr. S. D. the learned counsel appearing for the petitioners. Also heard Mr. Mr.
My lord, matter will be fixed for hearing in the month of June, my lord. The interim is enjoying, my lord.
Why June? Why so? I mean, why do you need so much of time? His pleadings are complete.
Then
As
before that, my-
Mr. Bokolial for respondent number. You're government advocate, right?
yes, my
Learned junior government advocate for respondent numbers. Mr. Datta for.
I'm PNRD department.
Mr.
One, two.
Datta for the learned counsel for PNRD department. Pleadings are complete in the matter. Let the matter be listed for hearing in the usual course in the later part of May, in the later part of the month May.
Interim orders may kindly.
Interim orders of past earlier shall continue till the next date.
Much of it.
Lord, respondent side is not ready.
Who is for the respondents? Who is appearing?
Mr. BK said.
May I please your lordship kindly pass over the matter for the time being?
Time being, no time being. Today it will be difficult. Who is the senior?
PK Sen.
Hmm?
PK Sen.
BK said,
BK Sen.
then it will be taken on Monday, Lord.
We'll put it on in the first week of May. First week of May. Monday it will be difficult. First week of May. Heard Mr. S.P. Roy, the learned counsel appearing for the petitioner. Also heard MS so-and-so on behalf of Mr. BK
Sen.
Sen. On the joint prayer of the parties, let the matter be listed in the first week of May. You need a date? You need a particular date?
2nd of May.
2nd of May, it will, 2nd of May, this is Saturday. Let the matter be fixed on 6th of May. 6th of May.
Please, your lordship. In this matter, I pray for a little accommodation.
Hmm?
A little accommodation. Mr. A.R. Bhuya will appear.
Who?
He's on- Mr. A.R. Bhuya, he's on leg, my lord, in another court. If possible, after some time, my lord.
My lord, I am for the respondent number 9, 10 and 11.
Readings are complete.
Readings completed.
Completed, my lord.
What is the matter about?
Matter regarding, my lord, regarding some parking place, my lord.
Huh?
Some parking place. We are allotted some parking place, my lord, which is occupied by the private respondents, my lord. And we have also made complaint, but no action has been taken. This is our, my lord, main crux of the case, my lord. After some time, my lord.
Today it will be difficult. I mean,
Then
some other
next
day.
week, my lord, a date may.
Heard Mr. So-and-so,
may I-
the learned counsel appearing on behalf of Mr. A.R. Bhuya.
Well.
The learned counsel for the petitioner, Mr. G. Bokolial, is present for respondent numbers 4, 5, 6, and 7. Have you filed, your pleadings are complete?
We have filed.
Pleadings
You
are
have filed.
completed.
Mhm. And Mr.
M. Doctor.
M. Dutta for
9, 10 and 11.
9, 10, and 11. Mr. So-and-so submits that Mr. A.R. Bhuya is a bit, A.R. Bhuya is preoccupied today and therefore unable to appear in the matter. Prays for some time. Let the matter be listed in the first week of May.
A date may be fixed, my lord.
First week of May.
Oblast.
May it please your lordship. In this
Hmm.
matter, your lordship, notice was issued and the respondents were directed to file their affidavit.
No
But the-
affidavit filed.
No
No, my
affidavit
lord,
filed.
instruction is yet to be received.
2024 matter.
Lordship, after issuance of notice, this is for
This is
the,
for
I
the
think,
second-
second time it has.
That
come.
doesn't matter, Mr.
Lord,
Borman.
Intimated yesterday, my lord, also. But
Heard Mr. A. Das, the learned counsel, appearing for the petitioner. Also heard MS M. Burman, the learned counsel, appearing for respondent number
3 and 4.
2, 3, and 4. MS M. Burman submits that she is yet to receive the instruction in the matter and prays for 2 weeks' time to complete her instructions. Let the matter be listed after 3 weeks.
Lordship.
Much obliged, your lordship.
My lord, in this case, I pray for some time to file my affidavit, my lord. I have received my instructions and I have sent for vetting.
You have received
Yes, I have received.
2025 matter, 2024
Even,
matter.
even government has some role to play here, my lord, because
You are appearing for the huh?
Union of India.
Union of India. Okay. And what about the state?
Lordship, we have not received any instructions.
Yeah, last time the state has taken time.
We have written the.
Okay, heard Mr. So-and-so. Huh?
Is it doctor?
PJ Dutta, the learned counsel appearing for the petitioner, also heard Mr. G. Pegu, the learned CGC for Union of India, as well as Mr. H. Sharma, the learned additional advocate general
4 and 5.
for respondent on 4 and 5. Mr. G. Pegu, as well as Mr. H. Sharma, pray for, as well as prays for some time to complete their instructions. Prayer is allowed. Let the matter be listed after 3 weeks. 3 weeks.
Lordship, my lord. Obliged.
17 and 18.
Item 17, we have filed affidavit, my lord.
Mm.
Whereas settlement is seeked for settlement of land, my lord. Whereas we are, our stand is, he has enough land in his possession, my lord, regarding invariant tax, my lord. So last occasion, they seek time for filing reply. And that reply yet to be received, my lord. In our affidavit in opposition, para, my lord, 6. Respective house numbers are mentioned, my lord.
None appeared for the petitioner when the matter was called for. Do MS M. Burman, the learned counsel, learned government advocate is present on behalf of respondent number
3, 4, and 5.
3, 4, and 5. G. Hazarika, MS G. Hazarika is present for respondent 1 and 2. Last opportunity is given to the petitioner to file additional
To file reply, my lord.
to file the affidavit in reply. If so advised, let the matter be listed after 3 weeks.
In item 18, my lord, some instruction was sought for regarding issuance of patta by the digital portal, my lord. Earlier occasion, my
But
lord.
no one is there. I mean, the 17, 18 are together, right?
But subject matter are different. I don't know.
But why
they
these
kept-
matters are
I
together?
don't know, my lord. At the behest of petition.
Anyway,
That-
none appeared, so you write the same, I mean, don't write about affidavit in reply. None appeared in item number 18. Let the
otherwise
matter be
it-
fixed after 3 weeks.
After extra, yeah.
No, is there anything which, I mean, whereby this matter can be disposed of at this
Lordship,
stage?
that is
Huh?
why I'm
But no
insisting.
one is
because
there.
No one is there.
Is so many instructions, what is there? 1 second.
That portal, last time that portal was not activated. Now Revenue Department has activated the portal, my lord. So they seek 1 week time for granting that digital patta. my lord. That is the substance of my instruction. In that case, my lordship may fix a short date, my lord, for disposal. Both the
This
matters.
matter, both them are the same is,
Advocate is the same, my lord.
Hmm.
Attending counsel is the same, my lord. So
Okay, let the matter be listed on Tuesday, next Tuesday. Both the matters, huh?
is
You keep it with you.
my lord.
Keep this with you, then you can produce the next. Or should we pass it over for time being? If somebody may come, then we can dispose of unnecessary pending, keep it pending.
Let it be on short date, my lord. That will be better. Otherwise,
Okay.
keep it.
Lordship, can this matter be taken up at your lordship? Lordship, can this matter be taken up at your lordship?
After 2, it will be difficult today.
At lordship, it
Well,
is for
we-
final
we-
disposal, it will take some time, your lordship.
Hmm?
Lordship, it is for final disposal, it will take some time, your
Then we'll
lordship.
put it on some other date. We'll put it on some other date. Today it may be difficult. I mean, there are some meetings and all,
Lordship, senior counsel, Mr. Ken Chaudhary also is appearing, Lordship, in this matter.
appearing in the matter.
Yes, Lordship. And Dr. A. Saraf is also appearing on this matter, Lordship.
If it is takes time, some other day.
If it,
We'll put it on some other date. Then. You give me a date.
Lordship, can we come after 5 minutes? After the
We'll talk with the court master, lordship, regarding the date.
For time being,
Yes.
time being possible.
Much
You just intimate what is to be done.
Yes, your lordship.
Yeah, because if it takes time, then like 2 o'clock, I mean, it is a long list. I don't think at 2 o'clock it will be, we'll be able to take it up.
Yes,
Madam, what is, I mean, what has happened to this matter? This, I don't, yes. 17, 18. You haven't filed reply.
Lordship, we have not yet received the patta.
No, in that
No,
matter.
you last 17, 18. 17, 18.
Yes, Lordship, in 17, I have to file some documents, Lordship, and in 18, Lordship, we have not yet received patta, Lordship.
Instruction has come.
Then your Lordship may fix after 10 days in the meantime.
No, why 10 days? I mean, this instruction has come already.
Yes, Lordship.
10 days, why do you need 10 days
But
time?
not yet received, Lordship.
What not
After-
received?
The patta not yet received.
No,
Lordship.
patta will be given to you. Then what
That
do you
1
want?
week time, they have mentioned 7
Because
days
they have
time.
stated that like online portal was not,
Activated.
not active.
receiving.
Now now we are fixed, then, okay, we are fixing it on, Tuesday. Tuesday we are fixing it on. Both the matters, okay?
In that
If you want to
matter,
file,
that 7 day may not be over, my
Huh?
lord. In that matter, they have sought for,
After
because
7
after activation, they have to arrange the thing, my lord.
how much time they are asking for?
They are seeking 7 days time, my lord.
They received it when? 23rd April,
Yes, yesterday I have.
yesterday.
Yes, my lord.
first week of May, lordship, any day. 4 or 5.
No, 7 days time, why do, why do they need 7 days time?
No, they have some exigencies regarding that portal has to be operated.
Now you are
to
saying the
business account.
portal is operated.
That
Now,
is
why did it
activation,
time?
activation is made by the revenue department, my lord. On
Mhm.
this count, it has to be working, my lord. And that the election is there, my lord, so they are.
The election is already over, madam.
No, for count.
The application
they are
for
little
digital
bit
patta
busy,
petitioner
my
will be
lord.
checked thoroughly. The DC level, digital patta will be provided to the petitioner within 7 days. If the application fulfill. No, no, 7 days time they are asking for, this thing, for verification.
Verification and.
Or approve,
Inductor-
or approving or rejecting.
Right.
Correct. So if your documents are there, they will give it. What is the point of you keeping this, petition pending?
That instruction is, we are
The
waiting.
instruction is that this portal was not active, that's why your matter was not considered. Now they are saying the portal is active, the matter will be considered. So they are,
My
you want
humble
consideration only.
Lordship, my
Then,
humble prayer before your lordship, after receiving the patta, your lordship.
no, after receiving the, why after receiving the patta?
Lordship, only because lordship.
No, see, they will verify and they will give you patta or not give you patta. That they will see whether the documents are, sufficient documents are there or not. So,
Recorded, after filing of this.
correct,
petition,
madam. See, like, if anybody files a document, files, for this kind of, services, they'll have to file online. They will verify it. And if it is there, they will give it to you. It is not guaranteed that they'll giving you the patta. And then how can this matter be kept pending till the time you are given patta?
Lordship, after filing of this writ petition, my names were recorded in the revenue records.
Correct.
After
So
issuing of-
they will issue you patta. But how can you, it can be guaranteed that you will be given patta only. They will see the documents.
Yeah,
We'll fix it on Tuesday.
dispose As for, item number 18, your lordship may dispose, but 17, lordship. it may be
17,
17 may be
Reply.
segregated, lordship.
but
It has to be segregated, my.
so, we are keeping both the matters on Tuesday, okay? Tuesday, you see, at Tuesday, if you can file it, you file it by Tuesday. If you cannot do it, then we'll see. But 18, item number 18, we are going to dispose it of.
Take care.
Tuesday.
21.
Yeah.
Government side is yet to respond. Yes. What is their stand? Actually, they have not yet responded to. After involved non-payment of proper compensation and without paying that, they have already demolished the. existing-
Who is appearing?
Government. Since earlier, my lord, attended by Mr. Goswami, my lord, PN Goswami.
APTCL was probably the
he is
PN
appearing
Goswami.
For all, my lord.
He is appearing for all.
Additional AG. One of the order, it is noted, my lord.
So is there any instructions, Mr.? You are appearing, Pathak?
I'm appearing for APDC.
And what about the other two? Other two, they're saying Mr. Goswami is appearing.
In this, since he was appearing as additional AG,
Hmm.
that he had appeared, absence, one of the.
Government advocate.
তেওঁকে নকৰে নেকি? তেতিয়াহ'লে convey কৰি দিবা, মই সময়টো লৈ লওঁ তেওঁ। Then in that case, my lord, some accommodation may be given. I
No,
will-
this was the last time given. There's a judicial order passed. You all should take care of this. It cannot be done like this. Last opportunity is given, then again a last opportunity will be given.
No, no.
How can I modify this order? It's a judicial order passed by one coordinate bench.
Yes,
Should we
lord.
take it after some time, let them.
It becomes difficult, no?
Mr. Goswami.
Petitioner মানে আছে, telephone line নে? No,
MS Mohand also appeared earlier. So what is your instruction? See, when a last opportunity is given by a court, and you should take care of this, all government advocates.
As for last
Oh.
order, my lord, R4 has taken instruction, my lord, FPDCL. Order dated 26/3/26, my lord.
Some accommodation may be provided, I'll do that.
Your name?
NZ Chaudhary.
Anjay Chaudhary appears for the petitioner. MSM Bormon appears for, you are appearing for, Bormon appearing for 2,
DC,
Mahanta for 1,
My lord, I'm for one.
2 and 3 I am appearing,
2 and 3. Mr. KP Pathak for 4. As per the last order dated 26/3/2026 of this court, the respondent government was to apprise the court about the instructions in the matter. However, the same is not done. A last opportunity is given again to the respondents, to the state respondents, to apprise the court about the stand of the government in the matter. Otherwise, the matter will be proceeded without the instructions. Let the matter be listed after 2 weeks.
My lord.
2 weeks.
Deeply.
Much of it.
I mean, 1920.
My lord, can a date may be fixed between 13 and 20?
13th of May.
Yes, any date.
After 13, Your Honor.
After 13, but not 15, my lord.
Fourteenth.
Hearing.
The parties are duly represented on the joint prayer of the parties. Let the matter be listed on 14th or on 14th, just like 14th.
Interim order that may be continued, Lord.
Interim order so passed earlier shall continue till the next date of listing.
Oblige, Your Honor.
Lordship, in this matter, I will file affidavit, Lordship. Instruction is awaited, Lordship.
Hmm?
Instruction awaited, Lordship. Date may be given, Lordship, to file affidavit.
One affidavit in opposition filed by R2. You are appearing for whom?
I am for Deputy Commissioner, Lordship. Kamrup.
When additional affidavit was directed to be filed, Lord.
Yes, Lordship.
No, one additional affidavit already filed.
That is different, Lordship. One more affidavit we were directed to file, Lordship, regarding notice under section 3 and 6 of Land Acquisition Act, Lordship.
You are appearing for whom?
Appearing for Deputy Commissioner, Lordship, respondent number 2.
Respondent number 2.
Yes, Lordship.
But respondent number 2 has already filed an affidavit in opposition.
Some additional affidavit were on the last step. These notices were asked to bring on record.
Mr. SD. The learned counsel for the petitioner. Also heard Mr. N. Kolita
And Colita.
for learned counsel for respondent number 2, as well as Bora for
Number 3.
respondent number 3. Mr. N. Kolita submits that do a direction was given to file an affidavit in opposition by order dated 8/4/2026 by this court. He is yet to receive the complete instructions, and therefore prayed for 2 weeks' time to file the additional affidavit. Player is allowed, let the matter be listed after 2 weeks.
That's okay.
As per the last order, because we have served the copies of our affidavit, it is in transit, we will file by today.
Yes, madam,
Yes, Your Honor, they're supposed to file a affidavit.
We have served the copies.
they said they have already filed it. But it is not on record, Mister, have you filed it?
No, no, Lordship, it is in transit by 2, it will reach, I will file it by today.
We'll file a reply.
They have
But
received.
they haven't filed it as yet, I mean. Okay, right, Mr. MS, your name
You
please?
Dwara.
Huh?
You Dwara,
You Duara, the learned counsel appearing for the petitioner.
petitioner.
Appearing for the petitioner, also heard Mr. BP Bora, the learned counsel
Respondent number 3.
for respondent number 3, and Mr. P Hazarika for
One in.
respondent 1 and 2. I mean, from your side, yeah, are you going to file any affidavit? No affidavit. Okay, Mr. BP Bora, Mr. Bora submits that he is going to file an affidavit today itself, full stop. And a copy of the same has already been served on the counsel of the petitioner. The learned counsel for the petitioner prays for 2 weeks' time to file affidavit in reply against the affidavit filed by the opposite parties. Let the matter be listed after 3 weeks.
Your Honor, interim order may be continued.
The interim order, so it was interim order, what was the interim order?
There is an interim order.
Okay, interim order so passed earlier, shall continue till the next date of listing.
Okay.
26.
Yes, who is appearing for the other side?
That's all, always I come and I see the other side. Once,
The oil corporation.
yes, this is my lord, the pleadings are come, there is some urgency in this matter. My lord.
We are appearing for whom?
One.
Respondent number 1.
Oh, your lordship will complete it at 2 o'clock, the matter can be taken up. There are other matters also, your lordship, I have seen,
Okay, well, I'm passing it over for a time being.
yes.
Passing it over for time being. Please intimate the counsel for the oil who is appearing in the matter. Earlier, who appeared?
M. Sharma, I think, my learned friend is Mr. Sharma. Maharshi Sharma is.
M. Sharma.
My learned friend will intimate.
Please intimate. I mean, if he is there, then I mean, how much time it will take, Mr. Das, otherwise? Because
myself-
list is long and
Yes,
we
I
have
know.
some meetings.
I think that maximum I'll take 20 minutes. There are only one point is involved in this case.
Okay.
Right? Only one point involved.
Okay, we are passing it over time being and
Your lordship wishes you to get 2 o'clock or there is no problem. Subject to your lordship's, because I have seen the board is.
board is long, that's fine,
2:52.
that's fine.
It's up
Okay.
to the court. Because
Okay, we will take it up at 2:30.
that's 2:30.
2:30.
Yes, that's.
We'll take it up at 2:30.
Seven.
'27 also, Mr. Didas was, I mean, this Didas was appearing. I think they missed it. I don't know. This 26, 27 may be analogous matters. It's not tagged, but it looks like they're same matter. Here also this IOCL is appearing. Okay, fix it at 2:30 only, both the matters. Later matters will, we'll take it up at 2:30. 26 and 27. Mr. Upadhyay, what is this?
Lordship, instruction is, it is a admitted amount, Lordship. So my submission would be, Lordship, may pass the order in the line of Tom Ali, Lordship.
Hmm?
In the line of Tom Ali, Lordship.
Line of,
In the line of Thompson Ali, Lordship, the 2008 4 GLT1.
what is Tamsir Ali?
Chronologically, Lordship.
Hmm?
The payment will be made chronologically, Lordship.
Chronologically means the
Lordship,
waiting list.
Whoever completed the waiting list, Lordship.
In this regard, my lord, and recently, from the same list, my lord, another case was filed that was disposed of, my lord, with certain directions. I have the copy, my lord, on this line.
So we'll direct it. I mean, we admitted amount, you pay it
Yes.
within some time,
Yeah,
within some
fine.
time.
Lordship, the chief engineer has to examine
That is already there. I mean, that
Lord-
you verify it and then you-
Lordship.
Uh, In breakup, I have given the amount, my lord, at page number 9, my lord, paragraph 6, my lord. Two items of work, my lord, on the same.
this is under irrigation department, right?
Yes, my lord.
So
Right.
remaining amount is
Heard
1,38,000.
Mr.
MAI Singh.
So and so the learned counsel for the petitioner also heard Mr. Upadhyay, N. Upadhyay, the learned standing counsel for
Irrigation.
irrigation department. The case of the petitioner is that the petitioner after award of a contract by the irrigation department has completed the work which is the work, what work you have done?
At
Construction of,
my lord, at page 8, my lord, and paragraph 5, I have. given
you are
details.
writing petitioner number 4. Who is
Oh, no,
petitioner
that
number
is
4?
not, my lord, that is wrongly for written, my lord, it's petitioner, one petitioner, only one. It's a typographical error, my lord.
What was the last line? Last line, don't we? Completed the work of construction of 0.60 M, capital M, diameter DIA, Hume pipe gated in LET at CH
Channel.
dot 8, you take it from here, phase 8, 8580.22 of branch canal of CM Datta Bund, BUND, I then stroke S phase in bracket page 2 under AIBP 2012-13 as well as raising, as well as re-sanctioning, raising, strengthening and widening of canal embankment of art from CH 2997.50 M to 304950 M of branch canal in bracket extension of canal system of CM Datta Ban irrigation scheme phase in bracket phase 2 under AIBP, 2023, 2012 dash 2013. The petitioners, the petitioner, it is contended that in spite of submission of bills and various representations, his bills amounting to then you do, in spite of submission of the bills and several reminders. The balance payment of his due bills amounting to rupees 51,527 and rupees 86,932 respectively for the aforesaid two works have not been.
No, Lordship. Balance amount is like now, Lordship, 1,38,000.
It's a total, my lord.
Total was, Lordship,
No, I am writing that
Lo-
balance amount is 51,000 in one work
No,
and other work is
Lordship,
thing.
Lordship, sorry, Lord.
So balance amount of so and so respectively for the aforesaid two works. Full stop. Your instructions?
Lordship.
Two works. Full stop. Then you write, Mr. Upadhyay, the learned standing counsel, has submitted an instruction received, submitted a document received from the executive engineer, Mongoldoi Dolgaon Sipajhar Division, in bracket irrigation, dated 18/3/2026, wherein which is kept on record marking X. Marking X. Then you write the aforesaid document dated aforesaid communication dated 18/3/2026 reveals that an amount of rupees 1,38,405 is due to the petitioner. Full stop. The learned counsel submits that this matter can be disposed of with a direction to release the payment within a stipulated time. Since the amount is admitted, by the irrigation department. Full stop. In view of the aforesaid, the instant case is disposed of with a direction to the to whom the direction
Chief
will go?
engineer, Lordship.
Direction to the chief engineer.
To verify, Lordship.
Chief engineer, minor irrigation.
Lordship.
Response number 2. Chief
That's
engineer.
not two, Lordship.
Hmm?
That's
Correct?
not two.
Chief engineer, minor irrigation, Assam, Chanmari, Guwahati, to release the payment. How much time?
Lordship, he has to verify, Lordship, first.
No, that I'll write.
Right, Lordship.
Release the payment within period of
4 months, Lordship.
4 months will be too much. Within a period of 2 months.
See,
Small amount.
That is correct, Lordship. Small amount.
Within a period
But
of 2
budget
months.
has to come, Lordship.
Within a period of 2 months of receipt of the certified copy of the instant order after due verification of the documents. Full stop. Next you write, the petitioner is directed to submit a copy of the a copy of the instant order to the aforesaid aforesaid authority at the earliest. In terms of the aforesaid direction, the instant petition is disposed of.
Obliged.
I will reply affidavit to the record that on 23/4/2026, yesterday, day before yesterday. I believe, my lord, this is on record.
This is on record.
My lord, the only prayer today before a lordship is if lordship can come to this additional.
No, we'll fix it for admission then on another date.
My lord.
Is there any urgency?
Yes, my lord. That is what I am trying to sort.
What, Mr. Sharma?
Other pleadings are complete.
My lord, may kindly come to page 137 of this additional affidavit, my lord.
No, you tell me the facts first. We are hearing the matter.
Yes, my lord, the facts
Lordship
is.
is hearing the matter today itself.
Okay, what is there for? I mean, it is for admission hearing. The pleadings are complete.
Lordship.
Now, if you all are ready, then we can hear it. I mean, there is no,
Lordship.
he is arguing it for the final
My
this thing.
lord, no, not final.
Then what? Then what else?
But just one photograph I would like to show it from the records, my lord.
Mm.
The private respondent in collaboration with in direct connivance with the government official respondents, my lord, closed my gate like this at page 137 and page 138, my lord. How can anybody leave like way? This is the ingress and egress of the whole campus has been closed by the goons with the association of the government official respondents. At least this process may be cleared, just this portion of the entrance of my.
Now, why it has been, I mean, there must be some reason. What is the reason?
The reason is this, my lord, that according to the private respondent, there was a demarcation proceeding, my lord. We did not receive any notice for the demarcation. One fine morning, the whole troop, police and government officials and the private respondents arrived at my spot and started constructing this bamboo wall, this tin thing, my lord. Tin structure. Cordoning of my entire passage. My lord, the revenue authorities' power is to demarcate and identify of the land only. They cannot uproot anyone. For eviction, it needs a order from the decree from the competent civil court. This is not done. This is not the way of demarcation. Even if it falls.
Yeah, Mr. Sharma, but why it has done like this?
According to us, Lordship, that the petitioner land falls under DAG number 313.
No,
And this-
there may be some dispute, there may be some.
Yes, Lordship,
dispute,
that
but,
is-
but how can this be done like this?
It is done by the private respondent.
With the
Lordship.
help of the official respondent.
That is their allegation, Lordship. We have denied it.
No, not allegation. We have this evidence. What allegation?
Hello,
You have evidence, we have
I am
evidence.
appearing for the private respondent, my lord, respondent number 7 to 12.
Hmm.
My lord, the petitioner's land is connected.
No,
with-
correct, but like, how can you, I mean, put
No,
it
no.
like this?
No, my lord, it was, my lord, the petitioner's land and the respondent's land fall under two different, my lord, circle, my lord.
Hmm.
Their land falls under the Azara circle
Hmm.
and our land fall under, my lord.
Hmm.
This one. Polasbari revenue circle, my lord.
But they are they are adjacent land.
Yes,
Adjacent,
yes,
adjacent.
adjacent.
They are adjacent land.
Adjacent.
Hmm.
So, my lord, Directorate of Land Records issued notice to the both parties. Both the circle officers were present. By using the GPS process, they demarcated the land, my lord. They draw a map, my lord. And according to the map, they, my lord, demarcated the land in presence of both the circle officers, my lord. LR from both the circle officers were also present. The petitioners were also present.
My lord,
So, my lord,
you were present at our
but
home.
land were demarcated, boundaries were shown to both the parties, my lord. Thereafter, my lord, they put the, my lord, fencing.
But the
So, my lord,
gate,
their land.
but
I'm
that,
submitting, my lord.
see, but that is the way, I mean,
No, my lord.
Passage, that is the
I'm
entrance,
submitting,
my
my
lord.
lord. They have encroached the 45 feet, my lord, around 3 kathas of land of the, in the affidavit of the state respondent is also, my lord, reflected that aspect.
But how can you
Their
stop,
land.
but they are using this for ingress and egress, I mean, like, I mean, how can
My
you?
lord, their land connected to two roads, man.
Hmm.
One southern boundary as well as the western boundary. They have blocked the, my lord, whole entrance of the, my lord, the southern boundary and the western boundary, and they, my lord, encroach the land of the private respondents. So, my lord, they are using this land. So, after demarcation, my lord, they have, my lord, one multi-storied building constructed towards the southern boundary and some shops, my lord. They rented it out, and those are constructed in the western boundary. So, my lord, lots of factual disputes are there.
My lord, may I submit, my lord? My friend said that we are encroachers. Kindly come to page 135. We are the recorded tenants since last 65 years. This is the Khatian. How can he say that we are encroachers? My lord, whatever it may be, presuming my friend's argument is to be true, nobody can be uprooted like this. Kindly see the photographs. Kindly see the photographs at page
Mr.
37.
Sharma, how can it be done like this?
The way, this is
Lordship,
the,
But they are saying that like in the presence of circle officers,
yes,
of two
we
circle
have annexed-
circle
we have
officers.
annexed photographs by
And like,
police.
I mean, if something is there, but ingress and egress, how can you stop it?
Their prayer
No,
for
Lordship,
interim.
in a demarcation proceeding, Lordship, we cannot.
But you have, Mr. Somua, you have filed a reply.
My lord.
I mean, you have not filed any IA or something like that.
My lord,
So, I mean, how can the interim order will be passed in on the basis of a reply?
no, my lord, the interim prayer, it is there in the main petition itself.
Correct, main petition itself is there, but now, I mean,
An interim prayer already heard.
My lord,
interim order
Already
already.
heard, my lord.
Hmm.
But
No,
and
interim-
thereafter,
Yeah,
my lord,
this-
case was-
is this a subsequent event?
no,
no, no.
It is not a subsequent
Not
event.
subsequent.
It was
Yes,
already there.
yes.
Already there.
Interim was heard already.
Yes,
It was.
on the motion day itself.
Then we'll put it for this thing, final
My
disposal.
lord, interim, lordship may kindly go to the first order of this court.
Let me see.
Whether interim was heard and interim was refused. But we should say
Then
the
the pleadings are
correct
complete,
position
then
of
we'll-
facts, my lord. My lord, during the demarcation, my learned senior friend has rightly said, my lord, during the demarcation, government authority cannot erect even a single post.
No, while, I mean, this is not a subsequent event. I thought this was a
No,
subsequent
no,
event.
this is not a subsequent event. This is the first cause of action. And see the photographs we have annexed. Page 37 of my petition, my lord. All the government officials present, they erected the tin wall structures, cordoning off my passage, my lord. In connivance with the government
May I
officials.
suggest, lordship?
Yes.
Lordship, as because initially no interim was passed, lordship, and all, and the pleadings are already complete, lordship may fix a date for final disposal. An early date, lordship, as per your lordship's convenience.
Well, no, my lord. My respectful submission, my lord, we deserve
No, we'll do one thing. I mean, I've gone through this.
As because this, the blockade of that road, lordship.
My lord,
that
armed forces,
subsequent-
muscle power, if is to be allowed like this to be exist, my lord, but people will have confidence upon.
Mr. Somo, please. I mean, those things has to be seen. Those things has to be verified. Only with your submission, the court will not go.
We have annexed
Correct.
photographs,
Now
my lord.
we'll see. I mean,
lord, we have
how
annexed
the
photographs.
photographs will not do. We'll see like what
And
is
we have-
what
and-
we'll see what is there, what is not there. That's why I'm saying, because whether this was a subsequent event, if it would
No,
have
it's
been
not
a
subsequent,
if
it's
it
not
would have been a subsequent event, the court would have definitely would have considered it and seen like what could be done. But it is, since it is existing from the point of the time the petition has been
Yes,
filed.
yes.
So this can be finally disposed of in a short date. That's what I'm thinking of, because it has to be seen. The documents has to be seen. I mean, it cannot be.
My
Done like
lord,
this.
then my lord fix a short date for.
We'll fix a short date. That's what I'm saying, because I mean, if it would have been a subsequent event, and immediate action is required, immediate direction is required from the court, then it would have been a different thing. But since it is already there, heard Mr. A. Somo, the learned counsel appearing for the petitioner, also heard Mr. N. Korita appearing for respondent number
7 to 12.
7 to 12, Mr. H. Sharma, the learned additional senior government advocate for respondent numbers.
Lordship, let me. 2, 3, 2 and 3.
2 and 3. Pleadings are complete in the instant matter, since Mr. Somoa is submitting that there is some urgency in the matter, and taking into account that the aforesaid aspect, let the matter be listed let the matter be listed on 6th of May.
My lord, 6th of May, my lord.
Should see.
That is a motion day, but we'll try.
Then we'll put it on 7th of May.
7 may not be well, because my lord,
Then we'll put it on before that, then 5th of May.
Well,
5th of May.
6th of May is all right.
6th of May?
Yes, yes.
Okay, 6th of May, then it,
My
I
lord,
mean, we'll dispose of this matter.
my
We'll try to dispose
my
of this matter.
all right.
Because it will need some hearing,
My lord.
correct? We'll have to see the verified documents. It
We are
cannot be passed.
Our anxiety.
We
is that-
understand your anxiety, but it has to be seen.
My lord.
Lordship may pray for some time. We have not received the instructions.
Okay. Or Mr. So-and-so, the
Yes,
counsel for the petitioner, also for Mr. H. Raman, the additional senior government advocate for the state respondent. Mr. H. Sharma, prays for some time to complete his instructions. Let the matter be listed after 2 weeks.
After 3 weeks, lordship.
After 3 weeks.
Lordship.
3 weeks.
31.
Yes.
My lord, instruction has been received, my lord. It says, my lord, the application is rejected by the circle officer as geotech photo not submitted and possession is disputed, my lord.
Certain position I have.
My lord, that has been already been,
So then you file an affidavit. or we can,
Otherwise, being agreed with this order, there is an appeal also lies.
because there is a provision of appeal.
Assam Right to Public Service Act, Madam, Section 8.
Lordship, I fix another date, will I have to take instruction?
Okay, next week we'll put it some other date.
No, Madam.
Heard, MS Roy, MS Roy, the learned counsel for the petitioner, also heard Mr. N Das, the learned counsel, appearing for respondent number
My lord,
3.
1 and 2, my lord.
1 and 2.
One, two, sorry,
District Committee,
2, 3, and 4, my lord.
and that's for 2, 3, and 4. G Hazarika for respondent number 1. Mr. Das has submitted that he has received the instructions. Full stop. He has received the instructions. However, the learned counsel appearing for the petitioner prays for some accommodation in the matter. Let the matter be listed on 29th of April.
20 and 4.
So we can dispose it off.
Yes.
The only thing is that let her be satisfied.
Yes, ma'am.
May it please the lordship. So in this matter, I'm appearing for the municipal board, my lord, response numbers 4 and 5. With their consent, my lord, I'm praying for time to file a response. We've got the instructions.
Mr. Bonik is standing counsel GMC.
Lordship, no, municipal board, my lord.
Municipal, huh?
Hailakandi municipal.
Oh, Hailakandi municipal. Okay. Heard Mr.
L. Deca.
L. Deca, the learned counsel for the petitioner. Also heard Mr. S. Bonik, the learned standing counsel for respondent number
4 and 5. 4 and 5.
4 and 5.
6.
Your name?
And Islam.
And Islam for respondent number 6. Mr. Sharma is also.
1, 2, and
1, 2, and 3. Mr. Bonik's prays for some time to complete his instructions. Prayer is allowed. Let the matter be listed after 3 weeks.
not sure.
After 3 weeks. After 3 weeks,
Right.
noted. 3 weeks.
In this matter, my lord, that
My lord, here, on other day, my lord, I have taken time to examine. Your lordship, in para number 6, my lord, of the instruction,
No comment.
Lord, all the cases have been rejected and forwarded to citizens for submission of justification. So, my lord, on this point, my lord, I am to obtain instruction from my.
No, I mean, there is an appellate provision.
If the rejection
my lord-
order is not received by them, then it is a,
If rejection order is not received by you, then you approach them, they will give you
he
the.
misread the line complete, my lord.
my humble
He
submission.
has.
All the cases have been rejected and forward to the citizens for submission for justification, correction.
Correction documents
Yes.
establishing
But, Your
residence
Lordship,
for 3 generations.
Your lordship,
on-
para 6, let me ascertain from my party.
No, you
whether they
have already been given time.
One suggestion I would
I
like to
have been
put, my
given
lord.
time, my lord. Today I have, yesterday it was a rejection. It was.
No, I mean, we cannot keep
My
it
lord,
Lordship, I
pending.
have already
Oh, my
talked,
lord,
have
Your
taken
Lordship,
matter with the
I have
authorities, my
not
lord.
supplied
They are suggesting, my lord, if he is giving all the necessary documents and resubmit it for a fresh consideration, that can be done
So
immediately.
appeal, no appeal.
Go ahead, they have suggested
Then you
not to
go-
go to appeal, they have.
And you need not
all
go
the
to the appeal,
documents
then you submit the
submitted
documents.
As a fresh application.
You need not
will
go
be
to
done.
go to the appellate authority. You can go to that same authority with the documents. They are giving you an opportunity.
Whichever
Then
fresh application, because earlier one is
see, I mean,
rejected, so
they are saying
will
that like you
provide
have
it.
not submitted certain documents, right? They have rejected it. Now you go with the documents. What this court is going to do?
And file a fresh application.
Yeah, you're not understanding. What this court is going to do?
Your Lordship needs to see that they said that rejected and forwarded to the citizens. That part is not correct, my lord. They have not supplied us rejection order.
So you go there. I'll pass an order to give you the order.
Yes, my lord, rejection.
I'll give it, the rejection order will be given to you.
In fact, my lord, speaking order pertaining to reasons, that is very much reflected in para 6, my lord.
No,
Anyway, I will
No,
instruct the
para 6 is, I mean, see, this is only a
Yes, it will be
para-wise
taken.
comment you have given.
speaking
You-
order. has
you
to
have
be
that
given
speaking
as per-
order?
No,
Huh?
that is as per section 8, they have to provide a speaking order also, my lord.
Correct, so
So,
speaking,
document direct,
the
document direct.
speaking order should have been actually
Yes,
produced before this.
Yes,
court.
ma'am.
He's correct in that.
That may
Yes,
be,
yes.
that may be
In
supplied
fact,
to
to
us.
that extent, coordinate benches has also given directions also, my lord, in earlier cases.
My lord, my lord,
Okay,
yeah.
will I give you a direction that they have passed the speaking order. The speaking order will be given to you. Then you, with the relevant documents, you can approach them.
file a fresh, my lord.
Refresh.
You can file a fresh application.
application.
So your purpose is, what do you want?
My purpose is, sir, my lord, only prayer before your lordship, till our fresh representation is disposed of, we may not be evicted without following due process.
No.
That is very much
My lord,
reflected, my lord.
that is necessary, my lord.
That is not required.
That is necessary because
para-
your lordship.
Kindly see the reply of para 8, my lord. There is no such step
Your
has been
lordship,
taken.
They will not permit, I'll not pass this order.
Your lordship would be pleased to see
No.
that regarding
That
para
blanket-
2 of my writ petition, my.
Suppose.
Para
correct,
2
my
of
lord.
my writ petition.
No, that cannot be done. I mean, that eviction is a different issue.
No, my lord, eviction is a different issue. Your lordship, as per Salahuddin, my lord, nobody can be evicted without giving notice.
Correct, they will give you a notice if they want to evict you.
Yes, my lord.
Procedure
Yes,
will
my
They
lord.
will give you a notice, they want to
That
evict
is
you.
my prayer, my lord. Without due process of law, we should not be evicted till
No.
disposal of our petition.
No, I will not consider that.
My lord. Your lordship would be pleased to see para 2 of my petition, my lord. Para 2 of my petition. Para 2 of my petition.
There is no prayer, yeah.
My lord, my.
No, Mr. No, but don't ask this court something which the court cannot give. We cannot give you any kind of stay order in this. No, I have seen that.
Your
You,
lordship,
you see the your prayer. What is your prayer?
pending disposal of this writ petition,
Hmm.
respondent in
Hmm.
general and respondent number 2 in particular may be.
No, that order cannot be,
From the
that
respective city land.
blanket order cannot be given.
Not blanket order, my lord.
Mhm.
Your lordship would be pleased to see Salahuddin. It is clearly said that nobody can be evicted.
They will
without
not
following
evict
due
you,
process
they
of-
will not evict you without giving you a notice.
It's very much.
They will not
reflected in
give you, they will
reply of
not
para
give
8,
you,
my lord.
they will not evict you without giving you a notice.
What my learned.
This is totally
What
different.
your lordship is
Hmm.
pointed out, my lord. I am on that.
Hmm.
That they admitted para 2 of my petition, my lord. Your lordship. Para 2 of my petition. your
Where
lordship.
they have admitted?
Yes, my lord, para 2.
Para
No
2 is
comment.
what?
On para 2, my lord, there is no comment as per instruction, my lord. Para 2, your lordship would be pleased to see.
Oh, no comment. So what?
No comment, no
Because,
comment.
my
means,
lord,
my
that
lord,
it
we are
is-
in
yeah.
possession.
That schedule
We are
is
in
not
possession of
appended
that
to the writ petition, my lord. That is why no comment.
My
Not
lord,
relating to eviction or anything other like
Your
that.
lordship should be pleased to consider that no comment means we are in possession in the land for 50 years.
No comment.
We have filed the application. That has been rejected, all right. We'll go for fresh application, my lord.
You go for fresh representation, they will consider it. I mean, that stay order or eviction cannot be done.
Land is not
No
appended,
stay
my lord.
order, my lord.
As
My
is
humble
pleaded in
submission to your
para 2,
lordship.
my lord.
My humble submission.
On
to
that
your
ground,
lordship.
petition has to be dismissed in
Without
limine.
following due process of law, nobody can be evicted.
I'm not going to that.
We are in
extent, my lord.
15 years in the
Right.
land, my lord. So, my lord, my humble submission, they will fresh consideration, there will be there. When there will be fresh consideration, till then. we
No,
have
no,
got
no, no,
15 years.
no.
He had not pleaded anything like Salahuddin in his petition, my lord.
My
He's
lord,
only
my humble
asking for
submission before your
settlement.
lordship, why it's not be stated before your lordship. I am stating the law. What
Lordship
is the
just find
problem,
one,
my lord? I
there
am
is a schedule
50
of
years.
lands, he is
They
asking for
said that
settlement. There
they
is
are
no
not
such
evicting
ever made.
us.
No schedule.
No, schedule is all right, but in the petition.
How can that be, my lord?
We find it.
Whole petition
While-
is one
while-
fictitious, my lord.
Why, my lord, my Salahuddin will not be flowed in my case, my lord. We are 50 years for possession, my lord.
Maybe for 100 years also.
And they said that they forwarded the petition, we have not, they did not annex the copy. They did not annex the copy. that was forwarded to us. My lord, when my learned friend is saying that we can file fresh petition with documents, then till disposal of the fresh petition, where is the problem to status quo? Maintain status quo over the land. Can they evict us and during pendency of our fresh petition, my lord? What happened to the fresh petition if we were evicted from the land, my lord?
For settlement here is also.
You are already covered, that has already been ordered.
My lord,
That has already been ordered here.
by your lordship.
This court has already passed on 25/2/2026.
My lord.
The order has already been passed.
But your,
That has already been, your prayer has already been considered. And after consideration, yeah, the order has already been passed. Then what else you want?
could not follow.
Yeah, on 25/2/2026, you see the order. You have the order.
In the writ petition, my lord.
No, that order passed by this court. 25/2/2026. Should I read it out?
My lord,
Should I read it out?
be kind enough,
Yes,
I am public.
consider,
Yes,
see,
number, my lord.
see, no, order passed by this court.
Yes, my lord.
See, considering the above, while this court is not inclined to pass a blanket interim order, this has been already considered what I are praying for. It is provided that in case there is a
Yes, my lord.
move,
Now I got it.
no,
Got it.
so it is already there.
That may be continued.
That is already
My
there.
lord,
That's
your
already there.
lordship, that order has been passed till returnable time. So my lord, my humble submission before.
No,
the-
that order is still there. That order is
that
still
may-
there.
That may be continued.
That order is already passed. So if they want to do it, they'll follow the procedure. That's all.
Yes. That may.
That will be done. That will be done.
That order may be continued.
Hmm.
Till this decision. That is my prayer.
But that is what this court was telling you, that if they want to do eviction, they'll have to follow the process of law. Without following the process, we cannot do it. It's already there.
That point may be mentioned by you in the disposal order.
Take it down, no? Heard Mr. M.S. Sheikh, the learned counsel for the petitioners. Also heard M. Borman, the learned junior government advocate, appearing for respondent numbers
2 and 3.
2 and 3. Mr. Mohanto, P.R. Mohanto for respondent number 1. So number 1. The petitioner's case is that the predecessor in interest of the petitioners were landless persons, as their lands were eroded by the river Brahmaputra. Full stop. Since they became homeless, they came in search of land and constructed their home and started cultivating in a piece of land, in the piece of land wherein they have been staying. It is the case of the petitioners that they have been staying in the aforesaid land for last 50 years. Last 50 years or so, full stop. Since they have been staying in the aforesaid land for a long time, they had applied for settlement of the land in terms of the notification dated 11/11/2022. 11/11/2022 issued by the Deputy Secretary to the Government of Assam, Revenue, Revenue and Register Management Department, Assam. Full stop. Full stop. Since their application was not considered and or responded by the respondent authorities and on 5/1/2026, certain official persons came to their land. They are apprehensive, came to their land, being apprehensive of eviction. They have approached, the petitioners have approached this court. Full stop. Next paragraph, notice in the instant case was passed on 25/2/2026, wherein the following order was passed. Right? Quotation, considering the above, while the court is not inclined to pass a blanket interim order, it is provided that in case, there is a move to evict the petitioners, the same cannot be done without following the due process of law, more particularly those provided in the rules framed under Assam Land and Revenue Regulation, 1886, and the interpretation made by the Honorable Division Bench in the case of Muhammad Salak Uddin versus State of Assam, reported in 2024 for GLT 857. Full stop. Quotation complete. While hearing the matter on the last occasion, that is on 25/3, no, that is on 22/4/2026, the Learned Government Council appearing for the state respondents have submitted a communication dated 20th April 2026, issued by the Circle Officer, Chapar Revenue Circle, Chapar, which is already on record. Full stop. Mr. The Learned Council appearing for the petitioner, Mr. M.A. Sheikh, sought some time on the particular date to take instructions. Full stop. Today, when the matter was taken up, the Learned Council appearing for the petitioner submits that though the instruction suggests that some order has been passed, but no speaking order has been received by the petitioner as yet. Full stop. Therefore, he submits that the speaking order should be handed over, should be issued to them. Full stop. The learned next paragraph, right? The MS Borman, the learned government advocate for the respondents, submits that a speaking order passed. Speaking order has already been passed, and the same will
It
be.
will be passed, my lord. No, as reflection is not there regarding passing of speaking order, my lord. They are just stating the reason for rejection. So lordship may direct to pass a speaking order. That will be better.
Then you write, submits that she doesn't have any instruction whether any speaking order has already been passed or not. But the application of the petitioners have been rejected due to insufficient documents. Full stop. She further submits that she has instructions that on submission of sufficient in submission of the required documents, the petitioners she submits that in the event of submission of a fresh application by the petitioners with the required documents, the matter, the application will be freshly considered
As part
by
of-
the respondent department, full stop. She further submits that, since no speaking order has been passed as yet, no, don't write like that, full stop, you write, cut that. In view of the aforesaid submissions made, this court is of the opinion that that a direction should be, in view of the aforesaid submissions, it is directed to the respondent authorities, concerned respondent authorities, to pass a speaking order of rejection of the application of the petitioners within a period of
1 week, my lord.
within a period of 1 week, and such speaking order, and a copy of such
Copy of
speaking order
Provided.
to be provided to the petitioners. Full stop.
Petitioner each, my. To the
petitioners
each.
To the petitioners I have written. So you'll get all of will you get, full stop. Then you write, in terms of the aforesaid order, in terms of the aforesaid directions, the instant petition is disposed of with the observation.
By order dated 25/2/2020.
No, I mean, no, I have already quoted that observation. In terms of the aforesaid order, the instant petition is disposed.
Safely open.
I'm sorry, my lord, CD is not yet updated, my lord, otherwise, my lord, I'll have rejected petition, and it's, there's some time for updating the CD, my lord.
You have taken time earlier also.
Yes, updated, yes.
Can we see the first order, Miller? Dates, and there was no notice on.
No, they have sent the CD, but it is not updated, my lord, updated up to, my lord, 18 of December. And
It was
earlier-
last listed on 7/4. Last listed on 7/4. Today is, I mean, what? Today is
7th,
23rd.
they have not taken, my lord, it was, we received the CD on 27th of March, my lord, subsequent to that, my lord, it was not taken back, my lord. And, my lord, at least 2 weeks time, my lord.
2 weeks time, not possible.
27 March, Miller.
2 weeks is too much, Mr.
And here, Miller, that he has already, Miller, submitted.
Okay, we will post it in the next week. But
Yeah.
otherwise, this bench will not be available, Mr.
My lord, on 30, my lord.
Huh? Oh, yes, 30th.
Because first is holiday, my lord.
29th, if possible. You get it, I mean, only updation is required to be done.
My lord,
29th will post it.
they have to taken back it, they have to taken back. And
You do something because otherwise the matter will go beyond this
My-
thing. 2 weeks, this bench will not be available. And this
My-
matter has to come before this bench.
Here we have already.
We can put it 30th also, there is no
My
problem.
lord,
30th also. we
Here,
can put it.
without going into the merit of the case, we have already placed with that regarding that notice, my lord, 35 notice, but
No, but we'll have to see, check it there.
here possibly it is
Check-
not
check it,
possible.
check it. I mean, we'll put it on 30th, you bring it. Or Mr. H. Chaudhary, the learned counsel appearing. And we cannot keep this matter pending for
My
such a long time. Mr. Parasar, you'll have to understand that this is a bail application. This has been filed on when?
The seventh time, my lord, possibly, my lord. First order was
February,
on,
my lord.
first order was on 8/28/1, my lord, 28/1.
Last part of that.
Now, Mr. Parasar, it will be difficult. I mean,
Last time.
you'll have to bring on 29th. Or otherwise we'll dispose it off on the
My
basis. 29th you will bring it on. And it already 3 months have gone.
My lord, 29, my lord,
You understand
I'll
our
talk-
difficulties.
today I'll talk to the.
You understand our
My
difficulties.
lord.
So please take care of this.
Today
It's a bail matter. I mean, you cannot put it for like this. Mr. H. Chaudhary, learned counsel appearing for the accused applicant. Also Mr. K. Parasar, learned APP for the state. Updated CD is not received. Mr. Parasar prays for some time. Let the matter be listed on on 29th of April. 29th April as the last opportunity to produce the updated CD. Otherwise, the case will be heard without the updated CD. Parasar, last opportunity because our hands are tied. We can't do anything.
Last order, 17th February.
আমি রিলিজ করি না কি
আরেকটা থেকে দিছে না এসডিও সদর আছে ভেরিফাই করতে হবে সদর মানে সদর কি এসডিও সদর কি এসডিও সদর
70 সো কিমান করে পেজ কিমান করে
লাস্ট অর্ডার
ওকে
Yeah, Mr. Nath, you have the calculation now.
Lordship, the amount, yes, Madam.
You were supposed to submit the calculation.
Lordship, the already kindly see page number 86.
No, last order, Mr. Nath. Last order, Mr. D. Nath, learned senior government advocate, shall furnish a copy of the calculation made by the committee to the learned counsel for the petitioners. Have you given him?
No, I requested them.
This
Copy is not furnished till now.
This copy I have given, Madam.
They're saying not given because there's a direction.
No, this page,
17/2/2026 order.
These two pages, Madam. The calculation.
Calculation, yes, calculation, whether you have given them, that's what.
As per my instruction, I have given, I'll give again.
I have not got it.
I'll give again. I have the,
Secondly, that rupees 10 lakh also is not released by them.
I have the
It
copy.
is a case judgment passed by 5 years ago. And this judgment is never complied either by this respondents at all.
Lordship, may kindly
And
take up.
somebody will retire, we have to again impede them. But this company is never paid.
2018 case.
Yes, madam.
We cannot be liberal in this.
Kindly take up page number 86, Madam.
Hmm?
Page 86. Page
86.
Yes, yes.
Hmm.
This is the part of the affidavit in reply, Madam. In fact, 86 is dated 31.
Once, this is, I don't know how they have,
This is the affidavit in reply filed by the petitioner, Madam. Filed by the petitioner.
affidavit in reply.
Affidavit in reply filed on behalf of the petitioner number 4 against the affidavit in opposition filed by respondent number 10.
Yes.
Kindly come to the last annexure of this affidavit. There is progress, my lord. In fact, the amount has been given. PWD department, they have their processing.
Last annexure.
Last page, 86, 31/8/24.
Yes.
Here, kindly see, this executive engineer has requested the council, learned council for the
To submit
petitioner.
these documents.
Yes, to submit this document,
Hmm.
and there the amount is reflected.
No, amount is reflected,
Yes,
correct?
the calculation part, my lord, my instruction is given. I'll give again, my lord. Today itself I'll give.
My lord, the calculation is.
The how calculation has been arrived at, that's what. Calculation chart.
Just, this was with me and just again I'll give, my lord.
This is,
So-
my lord, it is more than, my lord, 2 months, 3 months.
So this is.
I did not get the copy.
You please give him a copy because there was a direction. See, it's not the amount, it's about the, how the, amount has been calculated.
Yes.
That's what you need to give.
Yes, yes.
That was the direction, last direction in February.
No, it was in fact, my lord, anyway, my lord, I will give it.
You give it to him so that he can check it.
Yes, yes.
So when do you want to place it, Mr. Saikia?
My lord, for.
You
release-
give him a copy, correct?
For release
And
of-
let him verify this, whether the amount is, only about the amount, right? So amount is correct or not. Once he's verified the amount, then that amount can be released probably.
In fact, these are the documents, the department requires these documents to process it further.
Correct.
So
That-
he should submit the documents for at least
We have
delay.
submitted.
We have submitted documents along with a letter requesting them.
Where is the document, where is the document that you have submitted?
That my lord, copy has been received by them, by the executive engineer. And
No, correct, whether you have the copy?
That copy, my lord, has not been brought here, but that copy has been furnished by my settlement may record it. We have.
No, okay, fine, now,
Secondly, my lord, that 10 lakhs rupees, when we submit that, under protest kindly release it along with all the inheritance certificate, all this, they receive it. But the thing is, they're not releasing it. Let them say that I have not submitted.
My lord, regarding submission of document, my lord, that was sought for by the PW department. That was the affidavit that we
you
have.
have received it?
Yes.
You have
No,
received
sir,
it?
No, that I will have the instruction on. If it has.
He's
been-
saying that like he has received
Yeah,
it.
if it has been submitted to us, my lord, we'll process the proposal, my lord.
Till October 25, it was not given.
Yes, that is there in the affidavit.
So do you have any document, say,
In the reply, they have submitted that, my lord, they have submitted to us. So I will have the.
That I will place it, let it be fixed on Monday, madam. I will bring the letter of the receipt. They learned friends are not properly.
in their
instructed by
affidavit,
the
they have
court.
said so, Mr. Gogoi?
By the
Yes, in the
authority.
reply, they have submitted. So I will have the updated instruction.
My friends are properly not instructed by the authority. That is why it is more than, my lord, 8 years. That this compensation is not released by them. It is 8 years, my lord.
Mr. Gogoi,
Well.
you should pay them.
No. On that part, that's why
You
I'm saying that-
verified and paid him. I mean, and calculation part, you please give him a copy. Let give
So
him a
unless
copy,
that
because
amount is fixed, my lord. Again, the proposal cannot be, my lord, mooted.
correct. That's why I'm saying that you give the calculation, let him verify the calculation. Once the calculation is verified, then it can be processed.
Amount was calculated and given in 2018 itself.
Hmm.
It is under process. Demand proposal is given, but in the meantime, the
But he is
petitioner-
disputing the amount.
petitioner died.
We shall
And-
we are disputed
Hmm.
because we are entitled for 30% solatium, 12% interest. All these are not given. Under them, and 100% submitted, that we will give a fresh calculation copy. So we are expecting.
No.
Because
No, this is the calculation copy, my lord.
No, no,
10
this-
lakhs rupees,
this
this
is
is the
disputed.
calculation.
This is disputed.
No, my lord, Lordship's direction, kindly see, my lord. Lordship's direction is there. If this is a contempt case, the DC on the verbal submission of the petitioner cannot recalculate and enhance the amount. This amount we have given, if he is not satisfied with the amount, the forum is there, my lord. He has the remedy, my lord, if the amount is not satisfied.
That, what was the direction of the court?
Yes, Lordship may kindly come to page number,
Last order may be granted, Shriman.
page
Last
number
order.
23.
Last order, when that order was passed.
Yeah, last order I have already read
Yes,
out.
my lord. On
Already
that,
read out.
honorable
Page
court directed
23.
me to
Page
file this in
23. Yes,
a,
page
right
23.
calculation copy.
Lordship. Malad, I'll read, Malad, the page 23 last para. Mr. Bhuya, standing counsel, so-and-so, PWD department record to letter number so-and-so, dated 18/9/2017, whereby the executive engineer PWD roads, Gauhati City Division 2, Gauhati, had intimated that due to want of necessary fixation of amount for the payment of enhanced rate as per direction of the learned additional district Judge Kamrup Metro Guwahati dated 7/12/2001, the demand for fund could not be submitted to the higher authority for necessary payment to the present petitioner, Shri Prabhat Chandra Mahanta. From the said letter, it is apparent that the said executive engineer had already intimated the ADC Kamrup Metro Guwahati by letter number so-and-so dated 30/8/2017 with a request for fixation of the amount at the enhanced rate. From the perusal of the said letter produced by the learned counsel of respondent, it is clear that the act of coordination between the two departments had at least started, and this court, reposing complete faith as such action of the respondents direct that they would release the due and legitimate amount as per the award of the learned reference court referred above to the petitioner within a period of 6 weeks from the date of receipt of the copy of this order by the concerned department. The petitioner shall be at liberty to send the certified copy of this order by a registered post AD as on additional precautionary measure. However, keeping complete faith on the learned counsel for the respondents that they would send the copy at the earliest to the respective concerned officials, it is further directed that while calculating the amount, the same would be as per direction of the reference code indicating the interest part under section 28 of the LA Act of 1894. This was in the year 2000.
So that amount of 10,90,000 was calculated.
Calculated.
The
and
only
given.
thing is that he is now disputing that thing. So if you are disputing it, then there is a separate cause of action will arise.
Disputed means the court directed. him to
A
furnish
court
copy.
directed as per the reference.
Well,
They have calculated and come to an amount. Now your thing is that like whether you are agreeing to the amount or not, If you are disputing the amount, then of course, then you have a different cause of action.
My lord, that order stated.
Then you will be in difficulty, Mr. Saikia.
My lord, just a minute. Order has been specific
Hmm.
that release the 10 lakh rupees. That is also not the release.
Okay, now you have got the calculation, we'll put it in the first week of May. By that time, you have said that you have already furnished the documents
Yes,
then.
yes.
And if you are happy with that amount, that the calculation, you are fine with the calculation, then they'll process it.
Yes.
We'll file another affidavit
Hmm.
with correct calculation. If I get the copy.
In a contempt proceeding, then
This is not the copy. They are not there. Only order.
Heard Mr. R.C. Saikia, the learned senior counsel, assisted by so-and-so. For the petitioner, also heard Mr. D.K. Nath, the learned senior government advocate. For the senior, Mr. Nath is appearing for respondent number
Respondent number 7.
7.
DC Malad.
7, and Mr. Gogoi is
respondent.
Mr. B. Gogoi, the learned additional advocate general for respondent number 10. Mr. Saikia submits that though there was an order of order of providing a copy of the calculation by the learned senior government advocate, the same has not been given it to him. Same has not been provided to him as yet. Full stop. Mr. Nath submits that he will provide the same to Mr. Saikia during the course of the day. Full stop. Mr. B. Gogoi, the learned additional advocate general, submits that if the documents as recorded in the letter dated 31/8/2024 have been submitted by the petitioner before the concerned authority, then the same will be processed.
That will be released forthwith.
Same will be processed because you'll have to first verify the amount calculation.
No, that
You
rupees-
verify it, then give it to them.
No, that rupees 10 lakh. Under protest, they ask. Under protest, they ask us. So.
Mr. Gogoi, can you do it?
Well,
because-
process it, but I cannot make a commitment today that by within 10 days.
Let him process, then in the vendor, let him process, let them process.
With humble submission, there's the order under protest, they will accept your money.
Let them process it now, and then this case will be fixed on first week of May. First week of May, then if
That
they
means
will
after
process,
that
then
we place
updated
the
this.
First
Then
week of
on
May.
that date, some order can be passed. Let the matter be fixed on 5th of May.
Well,
5th of May.
The
You give him a copy, give him a
Definitely,
copy.
definitely. The present petitioners are actually legal heirs. The original petitioner died. Therefore, the next of kin certificate, death certificate already.
Oh, the already.
Given.
Already.
Annexures are given.
Yes.
So next date, on the next date, you bring that document also,
Yes, yes.
whereby you have submitted those documents.
I will place.
That please,
Their
please.
authentic signature and seal.
Correct. That you place it, then that
Yes,
it will be
yes.
better.
Only unfortunately that for last, the original petitioner left for heaven. Two petitioners left for heaven. And my lord, kindly see, it is 8 years. Judgment passed by Honorable Justice Ujjwal Bhuyan.
Correct,
It's
long
not
time.
carried
Yeah.
out by them.
So that's why, I mean, Mr. Nathan Gogoi will take care now. Please, because this is 2018 matter. Whatever, I mean, whatever you do, because there is a direction.
No, no.
But
All right.
I'll just rise for 5 minutes. Yes.
In this case, I seek little accommodation, 4 weeks time may be given, Lordship. The election is, that's why, Lordship. Otherwise, we have filed affidavit, they have replied, Lordship. I have to obtain some instructions regarding, Lordship, compliance, Lordship.
You have already taken time, Mr. Gogoi.
Lordship, but the election, that's why, Lordship, officers are busy, Lordship.
For weeks time.
Lordship.
Heard Mr. P.P. Datta, the learned counsel appearing for the petitioner, also heard Mr. K. Gogoi, the learned additional senior government advocate appearing for the respondents. Mr. Gogoi prays for 4 weeks time to bring in the instructions as to the compliance of the compliance of the directions passed by the order. violation of which is alleged in the present contempt petition. Let the matter be listed or listed after 4 weeks. You bring in, it can be closed, I think. this, this matter.
I will bring it, Lordship. Regarding Lordship, otherwise, they have filed also reply, Lordship. Our some part,
But contempt petitions are being pending, I mean, so much long.
from our part is there, Lordship. That's why, Lordship, I am seeking time, Lordship.
39.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 2 weeks. After 3 weeks. After 3 weeks, miss.
Okay, petitioner absent.
None appeared for the petitioner when the matter was called for. For the for the interest of justice, let the matter be listed after 3 weeks.
41.
In this session, we are required to take fresh steps upon respondent number 5, my lord. My lord, speed post, my lord. 2 days time may be granted, my lord. As per law, in order.
Heard Mr. So-and-so, Learned
H.R.
Counsel appearing for the H.R. Ahmed for the petitioner. As per the report dated 10/3/2026, no steps have been received by the section. Till date, full stop. Lord and Counsel appearing with the petitioner submits that he will take steps within a period of 3 days, within a period of, during the course of the day. He takes steps. You have already, why you have not taken steps?
Earlier taken step through registered post, my lord.
No, that 25/2, no steps has been taken, Lozima court support. Okay, petitioner is directed to take steps within period of 4 days from today.
42.
Maple. Per the order dated 2/3/2026, the service would away from the respondent 1, 2, and 3.
Yes.
I have come to learn that the respondent 1 is not in his office, so he is some.
So you would like to take fresh steps or what?
So Lordship may allow to dusty service upon the respondent number 2 and 3. And also allowed to implement the new incumbent as a respondent number 1 in addition. Because respondent 1.
Then you file a petition, then let the new incumbent come.
Yes.
Then you take the steps, fresh steps or dusting or whatever.
To the other respondent.
Other response. At the same time, you take the white twice, you take the steps, because you'll have to bring in the new incumbent. Mr. H. Chetri, the Learned Counsel, appearing for the petitioner, submits that he submits that he should be allowed 1 week time to file an IA to bring in the new incumbent as respondent in the instant case. Full stop. 2 weeks time allowed. Let the matter be listed after 2 weeks.
2 weeks, maybe, because I have submit one representation to the incumbent.
So you file an IA for bringing in that new incumbent, then that will be allowed, then you can take steps, whatever.
Obvious.
43.
Item number 39.
So please don't come like this. Don't come like this. I mean, in between you don't come like this.
Sir, I am relaxing the
No,
another.
then what can be done?
I am highly apologetic.
No, what can be done when the matter is, which matter you're talking about?
Lordship, item number 39, Lordship.
What was the earlier matter? We are in which item now?
43 has been called.
Huh?
43 has been called, man.
43. Then why in between you are coming? I mean, do you want to say that like the court is going in a process and like you are in a different court, that then whenever you are free, you will come and you will mention?
No, Lordship.
Then When the court is rising or when the court is sitting, then only you do it. You cannot do it in between. The order has already been passed. Don't do that. This is not a process. We also practiced in this court for a long time. We never used to do that, do like that. You are working with whom? Who is a senior?
SK Das, Lordship.
Huh?
SK Das.
Who?
SK Das.
He hasn't teach you anything. How the mention has to be made, how we need to be appeared in the court.
I'm sorry,
When a
Lordship.
matter is already order is passed and in between you'll come whenever you are free, then you will mention the
No,
court.
Lordship, I'm. Sorry.
When you are in a different court, that's a different thing. What I'm saying is that like once the matter is called, we are now on item number 43. Now you are saying that 39 some order is passed, I should modify the order. Is it the way to do it?
No, Lordship.
Then earlier also you have done the same thing.
No, Lordship.
One occasion, it seems like, if I'm correct. Don't do that like that. If you have something, some urgency is there, then you mention it when the court is rising or when the court is sitting, not in between. This is what 43. 43, I don't know 43.
Lordship, this is the office note dated 4/4/2026, my lord. Here, respond number, against respond number 6, no steps have been taken.
Also, we have could not calculate proper address upon the respond number 6, Lordship. But sometime.
Heard Mr. B. Deori, the learned counsel appearing for the petitioner. Also heard Mr. S. Borer, learned counsel,
Number 5.
learned standing counsel for
GMC, respond number.
GMC, respond number 5.
Respondent number one.
Mrs. Roy for
Respondent number 1.
respond number 1 and thus for 3. Mr. Deori submits that he should be allowed some time to take fresh steps on respondent number 6. Prayer is allowed. Let the matter be listed after 2 weeks.
44.
Lordship, service is completed upon respondent number 2, 3 and 5.
Heard MS so the learned counsel appearing for the petitioner. Seen office note dated 17/9/2025, which reveals that service on respondent number 2, 3 and 5 has already been completed. Let the matter be listed for admission hearing in due course.
In due course.
Mr. Andas is present for respondent number
1, 4 and 6.
1, 4 and 6.
45 and 46.
May please, my lord. My lord peruses the order dated 13th March 26, my lord. The petitioners were in fact given the liberty to approach the authorities, and accordingly that has been done on 2 occasions, my lord. However, the amount has not been released as yet.
What is the issue?
My lord, it's regarding the refund of e-stamp, my lord. The petitioners had purchased e-stamp, my lord.
Okay, that hasn't been done.
Cancelled, and that amount in fact has been verified.
Hmm.
Now the question is,
What is the amount of refund?
my lord, in WPC 3037 it is 1,12,840, my lord.
Another one?
And the other one, my lord,
Mr. Sharma, you have any instruction on this?
Lordship, we have received that instructions that this is a letter written by the Stockholding Corporation to the Sub-Register Gauhati regarding that refund of, actually, Lordship, this e-stamp, that amount is gone to the checker of that Stockholding Corporation.
Stockholding Corporation has refunded to you.
Yes, whether it is there, as because they have approached and we have received this letter with reference to your above letter as desired. Therein, we have verified the stamp certificate and the details of Salan by which the amount deposited in the treasury is given herein below. This much of instructions we have received. As because they have already approached the Sub-Register Gauhati. Let me get the instruction from the Sub-Register Gauhati what has happened to their applications. Whether this amount has come to the fund of
It will come to the sub-register, then
Yes.
it will be refunded, right?
Yes. Whether
it's-
it has come to the sub-register, that is not reflected in this letter, Lordship. We are enclosing here the photocopies of. documents of
Madam
Salan.
will post it on some other, let him take the instructions.
My application of copy to move the Lordship, I will verify regarding that application.
I give him a copy, give him a copy.
my lord.
Heard MS.N. Upadhyay, the learned counsel appearing for the petitioner, also heard Mr. H. Sharma, the learned additional senior government advocate for respondent numbers 1 and 2. Mr. H. Sharma submits that he has a praise for 2 weeks time,
Lordship,
2 weeks time to complete his instructions. Let the matter be listed after 2 weeks.
Great.
Both the matters.
Much of.
Your Lordship, local service is not completed in this letter. We have taken steps shortly, Lordship.
Okay, services heard MS so and so, RR Kotoki, the learned counsel for the petitions. Also heard
Respondent K. Sudhirul Bhava SK Talukdar. Respondent
so and
numbers
so.
1, 2, 3, and 4.
And here,
For 5.
Five. Service is awaited in the instant case. Let the matter be listed after 2 weeks.
Yep.
48.
The Lordship. See, as per office note dated 4/4 of 2026, Lordship. Person number 9 and 10 is same in CIS. But in repetition, name is different.
So what is to be done? There is some mistake in the, I mean, as far as the names of names are concerned.
Lordship.
So respondent number 9 is Roman Talukdar.
10 is Roman Talukdar.
Huh?
Number 10 is Roman Talukdar.
10 is number Talukdar, Roman Talukdar,
Nine
and
is
9 is Conmoni Talukdar. But it seems in the NI in CIS both
Name is Roman Talukdar.
Roman Talukdar. So it has to be rectified. It has to be rectified by the CIS only. Registry has to do it.
Lordship. In our repetition, name is correct. Otherwise, service is complete, Lordship. Others respondent.
Heard Mr. B. Deori, the learned counsel, appearing for the petitioner. Full stop. Mr. B.J. Talukdar, learned learned additional senior government advocate, is assisted by Mr. P. Deka, is present for the respondents. It is from the office note dated 4/4/2026. It is seen that in the CIS portal, the name of respondent number 9 and 10 have been recorded as Raman Talukdar. Full stop. Not that full stop, comma, whereas in the cause title of the instant petition, it is seen that the respondent number 9 is Conmoni Talukdar, and respondent number 10 is Raman Talukdar. Therefore, Talukdar. Talukdar. Therefore, it is seen that there is a mistake in recording the name of respondent number 9 in CIS portal as Raman Talukdar instead of Sri Konmon Talukdar. In view of the aforesaid, next para, in view of the aforesaid, registry is directed to do the needful for correcting correcting and uploading the correct names for correct names in respect of respondent number 9. Full stop. Let the matter be listed after 2 weeks. Let the CIS correct it, then you can the right her name. Your name?
We have received some instruction today, madam, this morning, lots of I will do.
What is the case about?
Non-registration of the police case, madam, Jagirod. My lord, now.
Yes, madam, what is the case?
Lordship, Lordship,
Like they are seeking for
There
some
is-
time. They are seeking for some time.
last time they were about to file their affidavit. Lordship. Particularly the respondent number 4, Lordship.
Now.
Mr. Talukdar is appearing for respondent 4.
Lordship, SP Morigaon.
RDMS so-and-so, the learned counsel appearing for the petitioner, also heard Mr. BJ Talukdar, learned additional senior advocate, appearing for
1, 2, 3, 4, 5.
for all the respondents.
2 to 7, up to 7.
1 to 7.
1 to 7.
1 to 7. Mr. BJ Talukdar has submitted that as far the grievance, as far as the grievance of the petitioner is concerned, he has received an instruction from the senior superintendent of police, Morigaon, Assam, dated 23/4/2026, whereby 7 days time 7 days time has been asked, has been requested to complete an inquiry whether a case has been registered or not.
Why the case was not?
Why a case was not registered at Jagirud police station? Full stop. He prays for, accordingly, he prays for 2 weeks time. Full stop. Let the matter be listed after 2 weeks. You can keep this with you. I mean, it is not required. You keep. We have recorded your submission.
But
It has.
give to.
এটা তো ডিডাসৰ আছিল ন? মানে হেৰি কোনকেইটা আইটেম আছে? 25, 26 and 27. 26 and 27. So yeah, এটা আপুনি ইন্টিমেট কৰিব 2টা বজাত ল'ম বুলি। কাৰণ 2টা বজাত কৰি দিব, আমাৰ মেডলাৰ ইংলিছ শেষ হৈ গ'ল। 2টা বজাত এতিয়ালৈ ল'ব পাৰিম। আমি ইন্টিমেট কৰিব ডিডাছক কৰি দিলে হ'ব, বা ডিডাছ বা তেওঁৰ জুনিয়ৰ কোনোবা যোন আছে পাৰিবনে? Yes.
Copy of registration certificate to establish the registered firm enclosing all annexes where name of all partners, said partners are mentioned, or incorporation, certificate of incorporation wherever applicable, or certificate of income wherever applicable. Then you could not have given that part bidders who have applied.
So when did you submit actually this?
I
this-
submitted thereafter, man. What has
After
happened?
the closing date you have,
Yes, what
and
has
before the LOA?
No, LOA.
Hmm?
My lord, yes.
Before the LOA?
After the LOA.
After the LOA?
After the LOA. But how it matters, my lord, I don't understand, my lord. How it matters with the operation of the TT tank trucks.
When is the contract concluded?
Will be, it's a period of 5 years, man.
No. I mean, signing of the
Yes.
conclusion of contract will happen when?
Conclude, these are all the signing.
See, one is LOA
Yes.
and another one is LOI.
Yes. One
Correct.
is
Now-
LOA, letter of acceptance,
Huh.
then the letter of work order. Will
Then work order, whatever,
Work
work
order will
order.
be given.
I mean, so if the contract is by the time concluded, before you submit this acknowledgement or whatever, then if the contract is concluded, then it may be a difficult, situation. But if the contract is not concluded, then it's a different
My
situation.
case, I will show it before this honorable.
Now
court.
you'll have to tell me when the contract is concluded.
Yes.
That will be a
No,
thing that has to be
It
seen.
has never been concluded.
No, contract concluded. I'm not talking about the completion of the contract. I'm talking
No,
about
no,
the
I'm
when.
not talking completion of the
Hmm.
contract.
Hmm.
Completion of contract
It
takes
will
so
happen,
long.
yes.
Well, that's not
But
the
when
case.
the
Conclude.
contract is concluded means.
I understood.
Hmm.
Offer has been given.
Hmm.
I accepted.
Hmm.
There is an agreement. That agreement is concluded.
So,
That's what your lordship is on.
Correct.
Whether that particular, that your contract,
Hmm.
whether it is a concluded contract.
Is it concluded or not?
Contract. Now,
Yes.
for A,
Hmm.
it is now as on date,
Hmm.
it is now before we challenge before this court.
Hmm.
Now, there is some type of interim order passed by this court.
Hmm.
And the court, whatever, it's an ad hoc arrangement.
Hmm.
It has been given to
So the-
ex-bidder, it is an ad hoc. Now, today, if your lordship allows the writ petition,
Hmm.
for a moment allow the writ petition,
Hmm.
then what happens, my lord?
Hmm.
Then they automatically, they have to, my lord, they have to enter into a contract with me.
Okay, so
And work order has to be issued.
status quo was given.
Status quo.
No, madam.
No, see
No,
the order.
Hmm?
No, let's see the order.
Let's see the order. What is the interim order passed?
Let's see the order, interim order, my lord.
Hmm.
It is 30th of January 2026.
Yes.
See,
After hearing the council, right? Para
Yes.
7.
para 7.
Yes.
After hearing the learning of party on balancing the equity provided if the scope of the work which was within the ambit of LOA earlier issued to petition number 1 has not been allotted to any third party in the meantime, status quo as on today's to be maintained till the next day. So these are all ad hoc arrangement. I will show before this court. Yes, I will now show, my lord.
No, what does it
No,
mean?
no,
by-
I will- I
what
will
does it
show.
mean by?
No, I will show.
Mr. Das, what does it mean by third party?
Other than me, my lord, there are other bidders. Other bidders.
Third party means when whoever has
Now there are
owned the
three-
bidding, right?
There are three situations here.
Hmm.
Please look into my note, para 2. Please see para 2 of my note.
Hmm.
Admittedly, the NIT was floated in a two-bid system, technical and price bid,
Hmm.
where clause 5 tender evaluation allocation criteria at specific provide. Now please see A. There is a separate evaluation criteria for tank trucks with different capacities. Because this, my lord, 7 metric ton, 14 metric ton, 18,
Different
21.
capacities.
Now if in Shillong, depend on the geographical area, my lord. So these are criterias. Number B, state registered TTs would be given preference, and C, TTs with lower age, that is newer TTs, will be given preference. Now I will show, my lord, by their affidavit. Now, let's see their affidavit. Please see their, see my rejoinder. Please see my rejoinder at page. And it will be easier because I have mentioned what is their stand and what is our reply. Which is the page? Who?
So, Mr. Sharma, I mean, there is no contract concluded as yet.
My lord,
Because of this order,
Yes, madam.
status quo
No,
order.
my lord. In fact, what has happened,
Hmm.
after the LOA was issued,
Hmm.
the LOA was one of the documents. My lord, if my lord kindly comes to page
No,
170.
you just take
Yes.
it now,
So
I will get time.
after the LOA
Hmm.
is executed,
Hmm.
there is a subsequent contract also which is to be executed
Correct.
between the two parties.
Hmm.
That contract has yet not been allotted or signed between the parties. The reason being that the terms and conditions
No,
of the-
between parties means who?
between the IOCL
And
and the petitioner.
the petitioner, I mean, he's challenging that.
Yes. Otherwise, my lord, what has-
Whether it has been signed with some other party.
My lord, what has happened, because this is not just the successful tenderers, bidders are not just one party or parties, my lord. There are multiple
There are
parties.
multiple parties.
There are multiple
But
parties.
as far as his thing is concerned,
It has been, my lord, we have taken a stand that there is an ad hoc arrangement which has been made. And it is the stand of the IOCL that assuming the petitioner does not
just
get the cut.
tell me any of you can tell me that what is the structure, how it is, I mean, how the contract has to be performed.
No, let me put
Let
this.
him.
Please see page 250. This is what 250, right? Paragraph 24.
Yes.
Paragraph 24. A perusal of Annexure 2 of the affidavit of opposition filed by respondent would reveal an allocation to other bidders, page 250, having 7 metric tank trucks were made in the following manner.
Okay.
My lord, see A. 285 number of 7 metric TTs were allocated for bidders other than the petitioner. Right, my lord? However, the remarks column does not mention the word ad hoc. Right, my lord? Now see B. 27 number.
So what does it mean? It means that like it has been given to them.
Now
it
see
is not a
B.
arrangement.
Yeah, now see.
Hmm.
27 number of 7 metric ton TTs were allocated for bidders other than petitioner with remarks column indicating the word ad hoc. Right, my lord?
No, understood. I just wanted to understand, I mean, how the contract is to be performed.
Now, my lord, thing is that now see, one last. Interesting. Some of TTs of 7 metric ton allocated to other bidders are older in age as compared to TTs of the petitioner. This is one of the criteria which was new trucks.
New trucks will be given preference. Okay.
And they have given to the older in age. So if this thing, my lord, will kindly see one thing, my lord. Original NIT, what it says, my lord? If your lordship looks into 362 at page 38. Today, why I'm saying it is not a concluded contract.
Mr. Das, I just wanted to understand the thing. See, there are particular amount that has to be carried, right?
Yes.
A particular
Quantum.
amount.
Yes.
And that quantity has been given in the NIT.
Yes.
That this much of quantity has to be transported.
Yes.
So we want trucks to transport it.
Correct.
So initially truck numbers were given that this much of truck, what is that trunk? TT will be this much. Then corrigendum came, then increased to some increase to 400. But they have given some preferences that new ones will be given preference,
Correct,
whatever that has been given.
Absolutely correct.
Now that has to be transported.
Yes.
Correct. So you have bidded. You are one of the bidders. And how many bidders were there? There may be many bidders. There may be many bidders,
Yes,
and
many
everybody will be having their own trucks.
Yes.
Now, some of the bidders have qualified.
Yes.
And some probably did not. And how the qualification has been?
Evaluation, 1 second, my lord. Evaluation has to be done on the basis of 7 metric tons regarding 362 increasement of 400.
Yes.
Yes.
Now,
this has to be done.
you have bidded for how many? What is your capacity?
My 10 plus 4. This is 10. Swati is 10. Another case is 4. 14.
10 what?
10 TT. 10
10
trucks.
TT.
Yes.
Okay, 10 TT is yours. And
Equivalent
40.
to 7 metric ton. 7 metric ton.
So your capacity is to transport 7 metric ton.
Yes, right.
By this 10 trucks.
10 trucks. Yes.
10 trucks.
Yes.
And during the time of 5.
It will be a period of 5 years.
5 years.
5 years.
So you'll have
Contract is for
you'll have
5
to
years.
transport 10. Sorry, what is the amount?
TT.
7
metric ton.
7 metric ton in a period of 5 years using 10 trucks.
Yes, 10 trucks.
You bidded for that.
Yeah, I bidded for that.
You bidded for that.
Yes.
Okay.
My eligibility criteria was it should be registered partnership firm, but certificate of firm that was not there.
Okay.
But they have
And
given a
this-
leverage.
That amount is fixed, like that is
Yes,
this
the
is
amount is
7
fixed.
metric ton,
Yes,
and you have given 10 trucks.
yes, right.
And other case 4 trucks.
Another is 4 trucks. And when they evaluated, your lordship is saying now whether it is a concluded. If it is a concluded, then the situation will be different.
That's
Your
what-
lordship will
that's
find it difficult to interfere. Let's be very honest to it. But what we say, it is not concluded
Because it is ad hoc.
on the face of their affidavit. Because what they say, my lord, on their affidavit, because you have a capacity of 400, your lordship kindly see 282 settle with some of the bidder respect of 7 metric ton, and some of the truck has not been settled, it is ad hoc, knowing fully that there is a matter which is pending before this court. And now three my lord, older in age.
So the question of conclusion will not come here.
Correct. That's the point, my lord. That's their own affidavit where we have given rejoinder. Otherwise, my lord, there is no question of looking into this matter, my lord. It will be academic discussion only. Now, only point where your lordship is to look into it, that whether it becomes a mandatory or whether it is.
Yeah, it's a directory kind of thing.
Directly. That's the only point. My only point where I want to make in this case is clause 4. Why this particular, exception was given? Page 50. Why this exception was given? Please look into that exception, my lord. Why this exception? Either you make it mandatory, my lord. Mandatory means only prior to closing date of tender, this is mandatory certificate, registration certificate from register firm is to be given. That's mandatory. Why you have given this? Bidders who have applied and are waiting for that means registration forms is not, certificate is not required. Yes, new firms is going to participate. You want more participation. You want doctrine of more level playing field. And this contract is something different, my lord. Because I have to purchase the truck, my lord. And this truck has been purchased. These are all new truck which has been purchased, not old truck which has been purchased. What I am on is only clause 6. Your lordship has to examine clause 6 at page 56. That's the one.
Clause 4.
I'm sorry, clause 4.
But you have to read clause 4 with 2.
Yes.
2
correct.
or 2.
Yes. Yes. Because, my lord, I'll show one judgment. Harmoniously, it has to be read. You cannot read one in isolation, my lord. You have to read harmoniously. Otherwise, my lord, I am asking myself.
Yes, Mr. Sharma has to answer. One thing, see, I mean, in this page 51, 51(2), 2 says, yes, these are the requirements. Then they put a condition there, right? They put a precondition kind of thing that the above constitution of bidders should be valid on the closing date of tender. So you have given a deadline. Deadline is the closing date. Now you are saying that you are saying the unregistered partnership firms, cooperative societies, company as on closing date of tender will be rejected. So that was your condition. That looks like a mandatory condition. That looks like a mandatory condition that, okay, if you are not registered, then on the closing date, if there is no registration certificate provided by you, then it will be rejected. Then you come up with this clause. Correct. Then now you come up with page 56. Page 56, you say, copy of registration certificate from registrar firm to establish the registered partnership firm, enclosing all copy of registration certificate from register firm, enclosing all annexer, wherein the names of all partners, details of partners and all, so and so. The bidders who have applied and are awaiting for registration certificate have to furnish the necessary acknowledgement slip and proof of deposition of requisite fees to the authority. So there is no deadline here.
No, there is a bona fide assumption on the IOCL that it may not be possible to cover all bidders who have applied for a registration certificate and have obtained a registration certificate pursuant or prior to the closing date. So the IOCL, in its utmost generosity, my lord, had given a clause that provided you have applied for.
But you haven't given any deadline.
We have not given any deadline. But my lord will kindly see. My lord, if I may permitted to make one small submission in this regard, my lord, the deadline issue, my lord.
No, that,
yes.
Then let Mr. Kamal,
Yes,
I mean,
yes,
we'll
but there is a submission here.
My lord, to this effect, my lord, it has to be harmoniously, it has to be read on the point of 6 and where your lordship has pointed it now. Please look into the judgment first, my lord.
Yes.
1991, 1 SCC, page 412, paragraph 14.
Para?
14, my.
Page sir.
Page 412.
Thank you, thank you.
My lord, it is a settled canon of construction that a contract of partnership must be read as a whole, and the intention of the parties must be gathered from the language used in contract by adopting harmonious construction of all the clauses contained therein. Cardinal principle is to ascertain the intention of the parties to the contract through the words they have used, which are kept to open the mind of the makers. It is seldom that any technical or pedantic rule of construction can be brought to bear on their construction. The guiding rule really is to ascertain the natural and ordinary sensible meaning to the language through which the parties have expressed themselves, unless the meaning leads to absurdity. So this is what it says. When, my lord, it has to be read harmoniously until it leads to absurdity. Well,
Understood, but
Yes.
but one thing we'll have to answer. See, I mean, do you want to say that like this certificate or whatever acknowledgement
Yes.
can be submitted anytime
But
during
they-
during the
No, they have not, and you see, my lord, what has happened? Technically, I was qualified because when this evaluation committee has said, and they know, because they are the best to know it, they also know that it doesn't have a deadline. That's why they allowed.
No, sir,
They issued an
that is why harmonious reading has to have some kind of meaning.
Yes.
Correct. The meaning cannot be absurd.
No.
So now if you want to say that no, I mean since this has been given, an exception has been given, I can submit it anytime. That you cannot say.
No. So now your lordship knows under the, when we file a suit,
Mm.
the effect of registration, what is that?
Mm.
Your lordship section 62, I think.
Mm.
69 of the registration of the partnership act.
Mm.
Partnership.
Mm.
That's only that is there.
Mm.
Suppose I want to sue,
Mm.
I can recover the money also
Mm.
is only by virtue of section 69.
Mm.
There's the effect. Please look into it, my lord.
Mm.
What is the effect of it?
Mm.
The effect is registration.
Mm.
So that's only, my lord. So how I am asking myself, how the IOC will be prejudiced to
They
this,
will
my
not be. No, that
Well,
question is
what
different.
how they will prejudice, my lord? My lord will definitely look into it. Number one, it is prejudicial to them. Violation of Article 14 also. Then your lordship will look into it. How it get prejudiced to them, my lord? I don't understand.
But contract has to be read as the contract
Yeah.
as it has been laid down in the
Yes,
contract.
my lord. Yes, your lordship is right. Your lordship is absolutely correct.
Mm.
There is no two ways on it, my lord. But if you see in what manner they have written this particular clause, please look into it, my lord. 51 has to be read with 56, my lord.
Hmm?
51
Hmm.
has to be read with 56. Please see 51. 51.
Yes, that I have seen.
Yes. My lord, I am asking myself, my lord.
Mm.
My lord, if this clause were mandatory, what they could have given, my lord? What they could have given if it was mandatory? That no, what we will do, the registration of certificate for registration of firm to establish the registration partnership firm, that is mandatory, and prior to closing date it has to be submitted. Why this clause is given thereafter, my exception? Only what? Somebody is applying it, acknowledgement slip has to be given, there is no deadline. Acknowledgement slip has to be given, okay, you have applied. In this case, I did not apply. But when the LOA is issued, my lord, now, my lord, as on date, I have got that certificate of registration, my lord. There is absolutely no problem.
Yes.
And they are not saying anything on that part.
Other than this, there is no other issue.
And your lordship will kindly see.
No,
very
other than this,
interesting.
there is no other
Yes.
issue.
And let me say, my lord, LOA when we issued, my lord, they did not say anything. They were silent on this part. They did not say or utter a word also. I came to this court, I challenged it, why a work order is not being issued. They come up and they say this. Yes.
There's no intimation given to you.
No, my lord, please look into the LOA. Please look into the LOA.
LOA where, page?
LOA, page 171. Please look into the LOA, letter of acceptance.
Yes.
Lordship got it, 69/2025, letter of acceptance.
Yes, yes, I was.
Now please see at 175.
You are pleased to so and so.
Yes. Please see 175, relevant portion 175.
175.
But these are the trucks. But see the list of trucks, my lord.
Yes.
These are the 10 number of trucks, right? Now see, as per terms and conditions, you are advised to carry out the following. See 4. To submit the documents, declaration, deposit as per the tender, complain all respect to his office at the following address. 1, 2, 3, I complied. 1, 2 have complied. Agreement has to be done. Yes, they have to inform. Yes, that's why I came up before this court.
Then
They
nothing,
did not-
then nothing was forthcoming from them.
Right.
So
but
that's
2
why
months
he
needed.
approached the court.
He approached the court.
That why work order was not issued.
Yes.
Then they come up with a stand that you have not submitted this.
Yes.
That
right.
is why work order was not
Yes.
issued. Then you challenge this
Correct,
thing.
my lord. And what is their stand, my lord? Kindly see. The order that has been impugned order that has been passed by them.
Yeah, where is that impugned?
Yes, yes. Please see that. At page 28, my lord.
Yes, 28, yes.
Please see page 28. Now see the reasoning and order. Please 30. Lordship got it?
Yes.
Page 30. Reasoning and order.
Yes.
Now see that 2.1.1. The requirement of having a valid residence certificate of the entity, in this case, partnership firm, from register of firm is contractually a pre-qualification criteria provided as mandatory tender condition for all bidders in terms of clause 4 of chapter 3 of the tender document. Any relaxation of any bidder on this aspect may directly result in violation of Article 14 of the Constitution. For other bidders shall be violative of the principle of equity and natural justice. My lord, in this case, they have not come across in their affidavit that is the violative of Article 14, because there are other bidders equally situated and we have not considered, and we are considering your case. That will be a total violation of Article 14. Not a single whisper has been mentioned in their affidavit. Yes, yes, boss. Please note, my lord. And if you read, my lord, 2.1.1, this is not a mess.
Yes.
My lord, if 2.1.1 is the reasoning and order, with great respect, I will say that reasoning itself is an arbitrary. Why? Why I am saying, I'll give an answer to it. Why it is an arbitrary, my lord? Why it is arbitrary? They can't say that this particular clause 4 is a mandatory in nature. What they are saying here, these having a valid residence certificate of the entity, in this case a partnership firm from register of firm, is contractually a pre-qualification criteria provided as a mandatory tender condition for all bidders. If that be the case, you could not have put that second clause, bidders only acknowledgement slip, and there is no deadline. Thereafter, you provide with a certificate of registration.
So I mean, that is their interpretation.
Their interpretation.
Okay.
And they said it will violate of Article 14. You show. They have not annexed any document to show, justify. They can't do it. They know. Now please look into the next 2.1.2. No?
Yes.
2.1.4 is major, my lord. This is most important. It appears, 2.1.4, it appears from the conduct of parties that Swati Logistics was fully aware they are falling short of tender requirement, mandatory terms and condition of possessing the registration certificate from the register of firm. Accordingly, the said certificate was applied from Messrs. Swati Logistic, where under no confusion that a registration certificate is not required by all the bidders for a tenderer. The chain of events and conduct indicates that Messrs. Swati never had the unreasonable expectation of no requirement of registration certificate for registration of firm. Now, please see this next para is very important. From IOCL conduct, it appeared the requirement of having the registration certificate was duly pointed out as early as 14/6/2025. However, there has been a confusion created caused by the production of registered deed of partnership accompanying the application of partnership, creating a reasonable confusion of being a document reflecting on the registration of firm. Specifically, now kindly mark this, as the scrutiny committee team does not essentially consist of people with legal background knowledge. My lord, kindly see this. This is what we pointed out for learned single judge. If you did not have that legal mind background, you could not have appointed those persons. They are the expert, my lord. The chain of events and conduct indicated it cannot be construed. IOCL was inclined to waive the essential tender condition of registration certificate from register of firms.
But what
Now,
about
throughout they were silent.
They have okay. They have dealt with this. They'll twist number 2 bidders
Yes.
at page 51.
Yes.
What about page 56 4? Have they
Four.
mentioned anything?
Yes, this is what
Where,
they
where?
said. Para 2.1.1.
No.
No, they mention about 2.1, which I
See,
read.
they dealt with this page 51. The
But
bidders.
56 dealt.
56 where?
Where? Page 30, 2.1.1.
2.1.1.
Yes, I'll just see. Line 3, my lord. Is content pre-qualified criteria provided as mandatory tender condition for all the bidder in term of clause 4.
Huh.
That is
No,
page 56, my lord.
That was I'm asking. That
Page
is
56.
that is what I'm asking.
Yes,
A clause 4 that way they have dealt.
yes.
Now clause 4 doesn't say mandatory, correct? Clause 4 doesn't say mandatory. Mandatory, if you at all say mandatory, then it is that page 51.
Yes, correct.
That it cannot be 4. So
Yes.
how you have dealt with 4, that's what I wanted to look into.
I'll
So
satisfy this
that 4 is only 2.1.1.
I'll satisfy this.
Nothing else.
Satisfy this.
Now, yes. So this is the order that has been passed by them, my lord. Or what? That's why I'm saying that if you read 51 and 56, my lord, 51 may make mandatory, but clause 4 in 56 is not a mandatory. That's what I am saying, my lord. My lord, and what interesting.
Just 1 second, Mr.
Yes. Any relaxation, you have given relaxation to all the bidders who did not have a certificate of rate.
Yes.
My lord, that's why I'm saying if you see the order, their order which has been reasoning and order, I think that's an arbitrary. Reasoning and order itself is arbitrary, my lord. 2.1.1. That's totally arbitrary. If you read 51 and if you read 56, my lord, this is totally contrary, my lord. 51 may be mandatory, but clause 4 of page 56 is not mandatory. It creates an exception, my lord. They have carved an exception to it. Now, my lord, let us say, my lord.
That they have come up with an exception and without giving a date.
Yes, this is our argument, my lord. Without any date, and an exception has been carved out. Because you, my lord, what has happened? They know that if this is mandatory, then participation will be less. That's why that exception has been given. Otherwise, that
now
particular-
Mr. Sharma will argue that this is mandatory.
Ah, let him argue that. He will argue, my lord, it is his duty.
He will argue, he will argue saying that you'll have to read this with this, the 2.1.
Hmm.
Anyways, anything else, Mr. Das? I think this is the point.
That's the only point, my lord.
Any case laws that you are referring
My
to
lord,
other than this?
One, this is what I have given. And Poddar steel, my lord. My lord will kindly see on my note.
Your note is there and
My note, kindly see paragraph 8, my lord.
as far as mandatory and directory, if you have some ready
Mandatory
references,
Poddar steel I have.
Poddar steel,
Yes,
the
Poddar steel.
reference can.
Yes, give me 1%. Please see paragraph 8, my lord. Which is the paragraph? 6 and 8, my lord.
Yes.
And my lord, let me be fair to your lordship, but these are your lordship note, the terms and condition which is given by the employer. It is to be interpreted by them unless you show there's an arbitrary or there is malafide. This is only to that extent judicial review. Other your lordship cannot go
Cannot
into
go,
it.
yes, yes.
Because your lordship knows right from the beginning. I remember Diaram Shetty,
Yes, yes.
Express newspaper, then Gigi Fernandez, all the Gigi Fernandez, Mahabir Auto, these all goes on in line. Earlier, your lordship knows the contractual was very confined, used to go to civil court. Thereafter, all the judgments came. Now, your
So
lordship.
only
we
the,
moved-
only the process, whether the procedure followed by.
For getting admitted amount, we come before the High Court. Because these are settled law by the Supreme Court. Otherwise, we remember we used to go for civil court. For realization of money, my lord. It has become dynamic and changed now. The law had changed from beginning. But only thing, Diaram Shetty today also, my lord, we point out. Article 14. That's your lordship knows that case.
Yes.
But that contract was over. That's why the Supreme Court says they will not interfere. Because he was not expert. So for airport, he is a hotelier. But that's why the court said, how can you pick someone where the terms and conditions are not being fulfilled? But by the time the contract was over. So the court said, no, we will not look into it. You cannot carve an exception. But here, my respectful submission 2.1.1, you have carved an exception. Because you know that it cannot be mandatory. It is only an ancillary. Otherwise, my lord, putting a question myself, what is the effect of it? Certificate of firm, registered. Even some bidders who is not having, only filing an acknowledgement slip. What is the difference? I'm asking myself, what is the difference between him and between me? Between him, he is not also having a certificate of registration or certificate of firm. Any bidder, that relaxation was given, that was carved out. They know that many bidders may not have that. Otherwise, what they could have done it, don't put that 3 sentence. It said that yes, because 51 is clear. Then what was the use of that 56(4) clause? That 3 lines, that who has applied, acknowledgement slip is sufficient, but there is no deadline. Now today, I applied 2 bid system, technical bid I qualified, financial bid also it was open. When financial bid was open, I waited. LOA should be issued to me on 16/9/2025. I waited. You did not. I waited and issue a work order. Even then, they did not point out to me that this is required because they know this is not a mandatory clause. When I came to the court, my lord, your lordship will be shocked. These were never the point before the learned single judge. The point was different, my lord. Kindly see, my lord. They were never the point. When the learned single judge, you decide, give a reason order, then this order was passed.
What was the point taken that time?
No, that point was different, but they did not dispose of the petition. Our whole case is LOA issued. Learned single judge, we don't enter into this merit of the case. We don't want to give any opinion on this case. What is there? Their petition is pending, you dispose of it, give a reason.
But there was no stand taken why work order was not given.
they have to take one stand. They say that no. This one is mandatory. Secondly, they are carving out. Third, they are saying this is a committee has been constituted. They doesn't have any legal background. This they overlook. Can it be? This is what when we move the second writ petition before this honorable court, my lord, this was what the observation was made by learned single judge. And see, please, the Poddar still at paragraph 6.
Yes.
See, yes. See, yes, on top. It is true that in submitting a tender accompanied by a check of Union Bank of India and not of the State Bank, clause 6 of tender notice was not obeyed literally. But question is whether the said non-compliant deprived the diesel locomotive work of the authority to accept the bid. Now important. As a matter of general proposition, it cannot be held. Authority inviting tender is bound to give effect to every term mentioned in notice in meticulous detail and is not entitled to waive even a technical irregularity of little or of no significance. The requirement in a tender notice can be classified in two categories. Now, please mark this. Those which lays down the essential condition of eligibility and others which are merely essential, ancillary or subsidiary with the main object to be achieved by condition. What is the object? My lord, suppose for a moment, my partnership deed was not registered. End of the matter. I cannot give an unregistered partnership to them. It has to be registered. It is not a case that my partnership deed was not registered. So now kindly see. In the first case, authority issuing the tender may be required to enforce them rigidly. In the other case, it must be open to the authority to deviate from and not to insist upon the strict legal, literal compliance of the condition appropriate case. Now, they made it, my lord, on the basis of Poddar still, my lord, they have 3 sentences of clause 6. There's 3 last sentence, they made it. That we are not in strict compliance. Whenever it is deadline not given, you just apply, give a slip to us, but we are not asking for that certificate of firms, incorporation. We are not asking. And one hand they are saying it is mandatory. So when you see the object to achieve is what? Object to achieve is not this. Or object to achieve that TT tank trucks, newer tank trucks. Because these are public interest, safety is important. Your Lordship knows, I remember that case. One case by the Honorable Chief Justice, I think Ranjan Go has dealt with. That case, what was that? That case was about trucks and tires, Michigan trucks. So that, see, my lord, what was that case? We have to see the safety of the public. Some Apollo, they came and they challenged it. But some tender was quoted by Karnataka State Authority. They said, how? No, these are a company, a very reliable company. We have, so reliability has to be seen. Now you brought some old tank trucks. Our is ad hoc. Our is a new tank trucks. In 2025, I invested in a purchase. What is the object to be achieved? I'm asking myself, my lord, Poddar said, what is the object to be achieved? Object to achieve, you have to see those TT trucks. These are all ancillary, my lord. Certificate of incorporation, you can, I am having a partnership deed, registered, 1. Number two, my lord, I qualified myself. Number 3, you have issued an LOA. Number 4, you did not issue a work order, I came to the court. Court said you dispose of the representation, we don't want to enter into merit of the case. You take a somersault and U-turn and you take a different view altogether by giving a reasoning order. One hand you are saying, no, these expert committee, technically they are not sound, knowledge they are not, legally they doesn't have a sound knowledge. How can you do it? So then why you have constituted this committee? Why you have constituted this committee who does not have a sound knowledge also? What they have done it then? So I think, my lord, Poddar still, my lord, appropriately fitting in this particular case, my lord. Please see, my lord, the requirement in a tender notice can be classified in 2 categories. Those which lays down the essential condition of eligibility and others which are merely ancillary or subsidiary with the main object to be achieved by condition. In the first case, authority using the tender may be required to enforce them rigidly. So please, I am putting a pause in this case. Now we bring it cross court. See the first three sentence of this, what it says. Then next three lines. So first is you have to have a partnership date. There is no doubt about it. Registered partnership date. And secondly, minus certificate of incorporation. Registration form. That is what is required. But that exception has been cut by them. Saying that no deadline. Whenever it is required, we will tell you. So I think, my lord, this is our case. And secondly, my lord, this is not a concluded contract. In their affidavit, if your lordship kindly see,
No, that part is clarified.
you're clarified.
That part
Yes.
is clarified.
And these are all ad hoc. which
Because
are-
the mechanism is different here. I mean, only LOA has been, and
absolutely
and
correct.
with other
Correct.
tenderers, other bidders, you have concluded a contract. You have signed the agreement.
Terms and conditions, I'll tell today, there are hundreds of judgments of Supreme Court cannot be put to challenge unless you can show it's arbitrary or.
No, you are not challenging that.
This is not, we are not.
You are not
we
challenging that.
Challenging also.
You are only saying that, I mean, your case is that this should not be a mandatory term.
That's the only point. If my learned friend can point out that this is a mandatory clause satisfied, then of
Whether
course I
it could have been rectified, the whatever was there, I mean, whatever,
today,
I mean.
I have got.
No,
it's not
no,
there.
no, correct. I mean, they could have rectified it. Had
Certain- my lord,
they.
there are cases where defective can be rectified also. Defective can be rectified. This is not a case of defective.
No. What I'm saying is that, I
Yeah.
mean, see, they are themselves, they are saying, admitting that maybe like it has been overlooked. Certain things
Yes.
have been overlooked.
Yes.
Because they didn't have the expertise.
Right.
Expert people were not there.
Yes.
Now, if they would have put some expert people there, probably they would have asked for rectification. Rectification of what?
Absolutely.
Rectification of the certificate, or like they could have called for this.
Yes.
That you have not given the acknowledgement slip.
Yes.
You give us the acknowledgement slip by this time, otherwise we'll cancel it. But that exercise could not be done because they themselves say that they don't have the experts.
They are saying now, they are saying now by taking that point. They, with great respect, my lord, they definitely have to be an expert. Only to cover up that they are saying that
No,
no, they have not.
Correct.
expert.
See, I mean,
To cover up. Otherwise-
mandatory conditions cannot be rectified.
Yes,
Correct.
right.
Only ancillary conditions, which are directory conditions, that can be rectified. So that he has to answer now whether this could have been rectified or not.
Yes.
If this could have been rectified, a matter would have ended by the time. But the fault is that like they don't have expertise.
Now, my lord, one last, your lordship, how can be rectified? Now, annual returns, in some cases, my lord, that additional documents cannot be given. These are mandatory clause. Now, I have seen in number of contract, annual returns has to be filed with. Now, they may ask for clarification.
Correct.
You cannot add and supplement with some new document. Add and supplement with new document. And what is important in this case, how they will be prejudiced in this case. But TT trucks are more important because they will ply on the road. These are the object to be achieved by them. This is the object to be achieved.
So as far as prejudice is concerned, that is like Podda steel, I
Nothing.
mean, object.
Yes.
Object. I mean,
Yes.
if the object is something, then the purpose is fulfilled. Then
Yes.
how they are prejudiced? That is
Correct.
that is your
Absolutely. That's what I
your
want to
case.
point out.
That is your case. I mean, whether you have any other references on that.
We will just find it out, man.
You find out because Podder is on the object. See,
Yeah.
each and Podder still with due respect. I mean, object, of course, object is there, but each and every contract, this court cannot go into that like what
No,
was the
your
object,
lordship
what
can't.
was the not object. That won't be possible. That won't be possible. So if there is something on the surface which is apparent that this was the object, then it can be
Like
maybe.
your lordship can't go through it. Suppose Central Coalfield, like it is like say as a bank guarantee. You cannot give by way of a fixed deposit. that you cannot change. This is an employer decision to take a decision on a bangare, on a particular, this is what the process,
Yes,
procedure has been
that
laid.
is their wisdom, they have
Your
quoted
lordship
it.
is not changing it.
Not changing it.
He's only finding out whether it's a mandatory or whether it's an ancillary. And the object to be achieved. That's the point, right?
Yeah.
I'm deeply all right.
Yes. Yes.
Manoj. I cannot possibly add on to the submissions my seniors made, but I just want to point out a few details.
Very small issue, Mr. This thing,
Manoj,
see,
true.
I mean, very small issue, I mean, now you'll have to show that, I mean.
That is a mandatory clause.
There is a default, there is
There
a
is a default
default
on their part.
that is
True.
and default in a clause which is of mandatory nature
True, Manoj.
and that cannot be deviated.
True,
That is,
Absolutely.
that is-
That's the extent of my submission, my lord. I'll not be going beyond that, my lord. Page 51 for a moment again.
Yes, yes.
Page 51, the last 3 lines of Rule 2.
Yes.
It categorically states, my lord,
Mm.
that unregistered partnership firms,
Mm.
as on closing date of the tender, will be rejected.
Correct.
Then, my lord, again,
Mm.
page 56,
Mm.
which your lordship had correctly pointed out, my lord, the bidders who have applied
Mm.
and are awaiting for registration certificate
Mm.
have to furnish the necessary acknowledgement slip
Mm.
and proof of deposition of requisite fees to the authority.
Mm.
Now, my lord,
Mm.
the last date of this tender
Mm.
was 12/5/2025,
Mm.
that my senior had rightly pointed out. What has also transpired, my lord, that there were subsequent amendments
Mm.
in this tender. And the date was eventually extended to a date which is, in any case, my lord, has not extended much beyond the month of June 2025, my lord.
Okay, it was extended to
Yes,
June.
my lord. Yes, but that is just my submission to clarify this code, my lord.
Correct, ठीक है.
Now, my lord,
Mm.
we'll kindly come
Mm.
to the letter of acceptance, which is at page 171. 171.
Yes.
My lord, that is the letter of acceptance which was issued to the petitioner.
Mm.
Now, my lord, towards the end of that,
Mm.
my lord will kindly come to page 175.
Yes.
As per tender terms and conditions,
Mm.
you are advised to get
Yes, 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 yes.
As
Mm.
per tender terms and conditions,
You are advised,
you
yes.
are advised
Mm.
to carry out the following.
Mm.
To submit the documents slash declarations slash deposits.
No, no, one second, one
My
second.
lord.
You are reading four, serial number
Four,
four.
my lord. I
Yes.
apologize, my lord, four.
Yeah, to submit the
To submit
documents.
the documents slash declarations slash deposits, comma, as per the tender,
Mm.
completed in all respects
Mm.
to the office at the following address.
Correct.
Then, my lord, we'll kindly come to the next page.
Mm.
Point number A.
Point number A.
Point number A, my lord.
Mm.
The contract will be guided by all terms and conditions of the tender and other documents furnished and related correspondence during the process, the tendering process slash period.
Mm.
All terms, then D, my lord.
Mm.
All terms and conditions stipulated
Mm.
in the tender notice, comma, special terms and conditions, comma, additional instructions, comma, special tender conditions, comma, declarations, comma, agreements and other documents furnished with the tender and related correspondence shall form a part of the contract. Now, my lord, I'll pause here and I'll bring your lordship's attention again to point number B. B.
Mm.
Formal work order shall be issued from the above office after physical verification of the TTs at the location and on submission of the required documents. The LOA was not the final document. It was not an LOI, it was not an LOA, my lord, it was not a formal work order.
Correct, correct. There's-
Now, my lord, this LOA was issued on 16/9/2025. Now, my lord, will kindly come to, my lord, page 177. At 177, my lord, we'll see the date of application for getting the registration certificate. It's 27/10.
Mm.
So assuming, my lord, that the petitioner had not applied for the registration by 12/5/2025, which was the closing date, but had applied prior to the issuance of the LOA, even then, my lord, the petitioner would have had a case that I have had applied. Now this is the LOA. Now I'm giving you a certificate to show that I've applied.
By the time the LOA was issued, my lord, the petitioner relied on the partnership deed. My lord, for a partnership as a bidder to have participated, my lord, there can be an individual participation as a bidder, there can be a partnership, there can be a company. Now, for all of these entities to showcase their existence in law, they have to furnish a document. As per the tender terms and conditions, my lord, the registration certificate was the document that is indicated for a partnership firm. They failed the deadline of 12/5/2025. They failed the deadline of 16/9/2025, and on 27/10/2025, which is a month thereafter, it is only when they applied for the partnership firm certificate, for the partnership certificate. Now, my lord, they have relied on the aspect, my lord, the order which is impugned 5/1/2026, my lord, which is at page 28, my lord. Now, my lord, we'll kindly come to page 30, where my learned senior has relied.
Yes.
Now, my lord, before 2.1.1, I beg your lordship's attention to point 2.1.4 first, my lord.
Yes.
It appears from the conduct of the parties that Messrs. Swati Logistics was fully aware that they are falling short of the tender requirement, mandatory terms and conditions of pursuing the registration certificate from the registrar of firms. Additionally, the said certificate was applied for Messrs. Swati Logistics, aware under no confusion that the registration certificate is not required by all bidders for the tender. The chain of events and conduct indicates that Messrs. Swati never had any reasonable expectation of no requirement of registration certificate of registrar of firms. Now, this is a subjective assessment by the IOCL, my lord. I'll not rely on this. The next paragraph. From IOCL's conduct, it appears that the requirement of having the registration certificate was duly pointed out as early as 14/6/2025. However,
Now, where by 14/6 to 2025, where?
now that is not a part of this writ petition, my lord. In fact, this was 14/6/2025. Annexure P3, my lord. Annexure P3. I apologize, my lord. And 140, my lord. 140.
140.
140. I apologize, my lord. 140.
Just pause for a moment and we'll see 140. what
Yes,
is
my
there.
lord. Oh, sorry. Queries number 3, my lord. Number 3.
No, queries by whom? I mean,
Queried by the IOCL, my lord.
IOCL has, 1 second.
Yes, ma'am.
14/6/201 page. Page 140. This has been done by whom?
My lord, page 140, communication, it's a automated communication, my lord, which has been preferred by the
It's
IOCL.
a communication by you, right?
By us, my lord, by the
By
IOCL.
by
the
you to Swati
Swati
Logistics.
my lord. Yeah.
Then you say that you submit to fail below mentioned documents.
My lord, queries number 3, my lord. The queries, the point number 3.
The queries by whom?
Queries by the IOCL, my lord.
Queries by ISL. Okay.
My-
Copy of registration certificate of registrar form established registered purchasing firm, not enclosing all annexures. Your names. Okay. Copies of the registration form.
My lord.
Okay. This has been pointed out to them.
This
That
is-
you are saying.
Then, now
Ah.
the next page, my lord.
Hmm.
This is a response from Swati Logistics, my lord.
Where is that?
My lord, 141.
Hmm. What is the answer?
The answer, my lord. Your lordship would see number 4, copy of registration certificate to establish the registered partnership firm and names of all the partners.
Regarding this, we have submitted an affidavit.
Yes, my lord, on a notarized stamp paper
Hmm.
and the registered partnership deed. So we sought for A, my lord. They provided us B, but be that as it may, my lord, this was preferred in the month of June
Hmm.
and in the month of September.
Hmm.
The IOCL,
Hmm.
inadvertently or advertently, my lord, had produced the LOA, furnished the LOA to the petitioner. But, my lord, a look at the LOA would clearly indicate that the LOA was also subject to a further round of scrutiny of the submission of documents which are to be provided as per the terms and conditions. My lord will kindly come to page 175, my lord. 175 onwards. The last line, my lord, point number 4. As per tender terms and conditions, you are advised to carry out the following.
But they have already submitted the documents.
No, my lord. No. Because, my lord, the entire picture is what has happened, my lord, is that in this tender, the reason I've mentioned there are subsequent amendments.
You have technically qualified him once, right?
My lord,
You have technically qualified him.
the qualification.
The LOA has been issued.
The LOA is not the entire finality of the document.
Correct. That much we understand.
My lord.
What I'm saying is
Yes.
that LOA has been issued.
No, no.
Now, what are these documents you're talking about?
Yes, my lord. So what has happened, my lord, we'll kindly see as a reference, my lord, page 176. The reason I'm
176.
176 number E, your lordship sees that in case trucks are offered under agreement to sale, ATS. Now, what had happened, my lord, in this agreement, in this tender, there was a clause which was inserted, my lord, in the month of April. So under that clause, my lord, that corrigendum, what it talked about is that if I'm participating in this tender and I have, say, 2 trucks participating with the IOCL in a separate tender, I can pull those trucks and bring them here, subject to the requirement of me furnishing the change of transfer of ownership and PESO license and all of that, or any other document if need be, within 4 months of the issuance of the LOA. Now, that was a small part of the entire tender. This LOA, in its usual entirety, my lord, takes care of any further documentation that might be required. Now, the reason this has been put in here, as my learned senior has rightly pointed out, my lord, that why would the committee, which is not versed with law, be tasked with carrying out the entire evaluation? In the IOCL, my lord, the primary aspect before it comes to the legal department is that the physical verification of the tank trucks happen. Thereafter, documentations go into the place, my lord. In this case, what had happened is that there was a verification which was taken place. Thereafter, the IOCL observed and noted that in place of the requirement of a registration certificate, they had submitted a registered partnership deed. Now, since no work order was issued, they approached the IOCL in the month of November 2025. To be precise, my lord, on 12th of November 2025. Before a lapse of 2 weeks, they approached this honorable court. So we had sat on the matter for only 10 days, my lord. We had not even taken a stand. We were about to take a stand. They had approached and the court granted us the liberty to consider the representation with a personal hearing and to dispose of the matter. We disposed of the matter by taking a stand, my lord, which has been impugned at page number 28. Now, my lord, the reason I'm referring your lordship's attention to the last 2 paragraphs, last paragraph at page 30, is that, however, there has been a confusion created caused by the production of a registered deed of partnership accompanying the application of partnership, creating a reasonable confusion for being a document reflecting on the registration of a firm. Specifically, as the scrutiny committee team does not essentially consist of people with legal background knowledge, the chain of events and conduct indicates that it cannot be construed that IOCL was inclined to waive off the essential tender condition of registration certificate from registrar of firms. In this regard, my lord, I would submit humbly, my lord, that there will be no estoppel in law to go and impose the terms of a contract or a tender which has been issued in public interest. What the IOCL did is that the IOCL digressed from the initial assessment of the IOCL and they found the petitioner not suitable under the terms of the tender matter.
No, they see, the correct, your thing is well appreciated, but one thing is, see, this court is little bit confused.
My lord.
I mean, see,
my lord.
You put a mandatory condition, right?
True, my lord.
A mandatory condition
True.
requesting that you'll have to give a registration of firms.
My lord.
And you do not have a person to identify whether it's a registration of firm or it's a partnership deed.
It's unfortunate, my lord. It's unfortunate.
It's very unfortunate.
It's unfortunate, my lord. Thankfully, we corrected that. Thankfully, we corrected that. Thankfully, tomorrow, no other tenderer would come and place that same accusation to the IOCL. We did something which we ought not to have done, and we clarified it, my lord. And the other question, other submission that I have, my lord, is that the impugned order dated 5/1/2026 has been challenged by my learned senior, my lord, rightly so, my lord. But the challenge is based upon two clauses in the NIT which has not been challenged. Now, my lord will not set aside that impugned order without the entire ground being assailed. The petitioner had not challenged clause 2, page 51 and page 56, my lord.
No, they are not challenging that.
They have come and challenged the interpretation of those clauses by way of the impugned order.
They are only saying that like whatever the they are only saying that, see, there are a lot of contracts in deeds
My lord.
wherein you'll find this specifically written, this is a mandatory term.
True.
Correct.
True.
In lot of contracts, that is not specifically
True,
written.
true.
So if it is not specifically written, then it is left to the employer. I mean, employer means like whoever the calls for it.
True.
So what is the correct, correct interpretation?
True, my lord.
Because they have drafted it with their own wisdom,
True, my
right?
lord. True.
Now, thing is that like if somebody finds it, no, I mean, this is not correct, then they come to the court. Then court has to, I mean, adjudicate on the matter. That is to see,
True,
I mean, see the object, see the,
True, my
lot many
True.
things has to be seen.
True, my lord.
Then you have to see whether there was some arbitrariness is there or not.
Exactly.
So now their challenge is only that. Their challenge is only to the effect that if these two clauses can be, if these two clauses are read together, then it doesn't look like a mandatory clause. That's it.
True.
That
In
is
fact, whether it is mandatory or not, that question, my lord, in my utmost humility, my lord, to the submission that my senior has made, had those application receipts been produced before the IOCL, before the issuance of the LOA, I submit on oath, my lord, that I would not have had a case today, my lord, that before the LOA, they wanted documentations to be provided, the petitioners had applied for it, and then they produced before the
okay.
IOCL.
Understood. Understood.
But
Now,
today, my lord, in the month of October, 1 month after the issuance of the LOA, they had merely applied for it. Now they cannot stretch the ambit to that extent to say we do not know whether it was ancillary or mandatory.
no.
Even if a condition which is ancillary has to be in some form or manner be construed. Now, my lord, we see the decision that you have taken by way of the impugned order at 5/1/2026. Your lordship would see, my lord, in my humble submission, that did we go outside the parameters of the tender? We did not go out of the parameter of tender. In fact, we corrected a wrong which was done by us by equating a partnership deed with a partnership registration certificate. Now, my lord will see whether I, as an IOCL, or whether this honorable court, my lord, can interpret and lay down that whether the IOCL ought to have accepted or rejected based on the issuance of the LOA. The LOA does not confer any right. The LOA, my lord, your lordship had seen upon the construction of the LOA itself, that the LOA was a document contingent upon submission of documents. And if those documents were submitted in the month of September, the partnership firm, the registration certificate could not have been procured by the petitioner. It was procured a month after the LOA was done. The IOCL has not gone out of the parameters of the tender, my lord. We have stayed inside.
So LOA
is a contingent document.
It's not a contract concluded.
My lord, because yes, my lord, my lord, this is one point I wanted to point out, my lord, because the lordship had correctly raised that point, my lord. Page 175 for a moment, my lord. Page 175.
Yes.
As per tender terms and conditions, you are advised to carry out the following, my lord. Point number 1, to furnish required security deposit of rupees 2 lakhs within 15 days of the date of issue of this LOA and execute the agreement as per terms and conditions. Now, where do we again find the reference? Number 3, execute standard agreement within 30 working days.
Correct. The execute standard agreement is a formality. See,
Here, my lord,
a contract is concluded when
you signed, my lord, executed.
Now, whether the acceptance of their offer is concluded contract or not.
So, my lord, here the LOA was an offer. The consideration was not paid by them because the terms and conditions could not be fulfilled. Hence, the agreement was not given.
Just sorry for disturbing my understanding. I think that the last question that has been put forward, I kept it with me. I know that question may be asked last. What is the effect of letter of acceptance? Whether that is now that has been decided by this court. I appeared for division bench negated that. Letter of acceptance, yes, they said this is a contract, letter of acceptance. Please see paragraph 10. No, last,
No,
sorry.
please.
I have asked, sorry.
No.
See paragraph 10. This is a contractual matter, my lord. It's a railway. I went to a division bench. I was not to learn a single judge. See paragraph 10. Only paragraph 10. WPC 710 of 2022. 710 of 2022. This is a railway contract, my lord. I appeared for division bench. I was not to learn a single bench. This is upheld, the order pass. That was the precise, I want to argue paragraph 10. See paragraph, before further stating the fact, it would be relevant to understand the effect of issuance of letter of acceptance and subsequent issuance of acceptance by petitioner form to the letter of acceptance. A contract is a bilateral transaction between two or more than two parties. Every contract passes through several stages, beginning with stage of negotiation, during which the party discuss and negotiate proposal, counter proposal, as also the consideration resulting finally in the acceptance of the proposal. Proposal, when accepted, give rise to an agreement. In the facts of the instant case, pursuant to the notice inviting tender dated 25/8/2021, petitioner's firm submitted his proposal on 21/9/2021, and the same was accepted by issuance of letter of acceptance 8/10/2021. Issuance of letter of acceptance amounts to allotment of contract, and letter of acceptance have been duly accepted by the petitioner firm, and a contract came into existence. Further to that, clause 5 of letter of acceptance dated so and specifically mandated all other terms and conditions of tender shall be applicable. By virtue of clause 4 of the letter of acceptance, petitioner firm was required to execute the license agreement, which was a formal document within 15 days from the date of issuance of letter. Here, my lord, if your lordship looks into 16/9/2025, there are 4 conditions which was given. All first 2 conditions complied. Third has to be complied. Fourth, third, my lord, only an agreement has to be signed. Once this, my lord, was put to challenge for division bench. I can give the number. Will have read appeal. My contention was different, my lord. My contention, we said the letter of acceptance cannot be is not the final execution. When we commence the work, that will be the terms. Final, the letter of acceptance. But the learned thing is a letter of acceptance. Your lordship has looked into it, paragraph 10. So if that be the case, this basically clause we challenge entire, but that was upheld by the division.
But that plea you have not taken.
Where?
In this case.
No, that
This is a concluded contract, letter of acceptance has given.
A judgment which this is your lordship has put a query on, that's a point, whether letter of acceptance, because that was not a part. Your part was that whether, my lord, whether it can be termed as a mandatory or it is ancillary. That was a point, clause 4. But letter of acceptance was given by them. Now a question has been put forward. What do you mean by letter?
So when you approached for the second time,
Yes.
that plea you have not taken.
No, maybe I am not. This is a,
You have not taken that.
this is a legal point, my lord. Of course, this is a legal point.
Yes.
And by challenging the terms and conditions, that is not my case. Why I will challenge
No,
those
that is
terms
not the
and
case.
conditions? That
No,
is not-
why this court was asking from the very beginning that whether it's a concluded contract or the purpose was that only.
Yes.
Since LOA has been issued,
Yes.
then now whether, once the contract is concluded, whether you can, U-turn
Yes,
and
yes.
not give the work to them.
Make a somersault and now invalidate. That's the point, man.
So
Now
what-
tomorrow, if the lordship finds that LOA is like one type of a concluded contract, then you cannot go back and ask that.
That's what I'm asking. That's what I'm saying, that if LOA has already been issued and a contract is concluded,
Yes.
now only way you can do and one thing that you have to terminate the contract.
Yes.
You have to cancel the LOA. If you want to cancel the LOA, then you have to give the damages to you. That has to be given to him. So now he is arguing that this is a contingent contract. This is not a concluded contract. That's what they are saying.
Yes, ma'am.
Yes.
My lord, my senior has referred to paragraph number 10, my lord,
Hmm.
of the judgment, my lord, which has been just referred.
No, that we'll look into it later on.
Yes, my lord. My lord, just I would
Hmm.
like to reproduce
Hmm.
the last 5 lines, my
Hmm,
lord.
hmm, hmm.
further to that clause,
Mm.
further to that.
Acceptance, you're saying,
Yes,
yeah?
yes, madam.
Whether they have accepted or not.
Yes,
That letter of acceptance has been accepted or
or
not.
not. In that case, my lord, further to that,
Mm.
Clause 5 of the letter of acceptance dated 8/10/2021 specifically mandated that all other terms and conditions of the tender document shall be applicable,
Mm.
which is similar to this LOA.
Everywhere it will be there.
By virtue of clause 4 of the
Mm.
letter of acceptance, the petitioner firm was required to execute the license agreement, which was a formal document within 15 days, which is similar to number 3. But the requirement of furnishing all documents, which was warranted by the NIT, is missing here, madam.
The only missing document is, as per you, only
ma'am.
missing
The
document is
copy
the
should be.
certificate.
The ratio of a case, in my humble submission, has to be decided on the facts of that particular case.
Correct.
My lord. We cannot have any.
No, this is the principle.
This is the principle
This
in
is the
that.
principle. I mean, the principle means like, I mean,
Yes.
principle, I mean, if you give so many contingent things,
True.
the conditions, preconditions in the LOA, then it doesn't become an,
Yes,
it
true.
doesn't, then again it becomes an offer from your side.
Yes, madam.
Then they'll have to accept it.
Yes, madam.
Correct?
Yes, madam.
So it will, I mean, whether, I mean, in a letter of acceptance, whether you can put those conditions or not, that is also one legal aspect we will need to
That
look into.
explains them, madam.
I mean, so once you issue an LOA, then again you are giving an offer, counter offer to them, saying that like, you'll have to fulfill those conditions, then only I'll conclude the contract. Then it becomes a different thing altogether.
In fact, the peculiarity of the NIT
Mm.
in this case had mandated that the LOA could not be an open and shut document because there are certain, my lord, the IOC in this tender, my friend would be aware of this, my lord, my friend assisting my senior, my lord, that there were provisions made in the NIT that you could submit certain documents 4 months after the LOA was issued because the tender was meant to assimilate and accommodate as much tankers, my lord, could be as possible. But the fact also remains, my lord, that the IOCL cannot deviate from its own terms and conditions. Now, if the petitioner
No, understood that. No, I understood your
My lord.
contention. So your basic submission is that this is a mandatory clause. It
This is a mandatory clause, my lord.
Mandatory clause, but though there was some mistake earlier that has been rectified.
There is no estoppel law.
It was rectified. There is
My-
no estoppel.
My lord.
There is no estoppel. Now you tell me, the learned senior has argued one more point.
My lord.
That object and being prejudiced. How
True.
you are prejudiced?
Now the
And whether this, now you'll have to submit on whether this prejudice, concept of prejudice will come in the contract or not.
Yes. Now, my lord, the object which has been sought to be achieved,
Yes.
the object which has been sought to be achieved
Mm.
is the transportation of LPG. And there is no dispute to that matter.
Mm.
Now, had the petitioner been successful fulfilling the terms and conditions, we have surely onboarded the petitioner. Now, my lord, what had happened is, your lordship would be aware that in the last round of litigation,
No,
Which-
let us cut it short.
yes,
I mean, see, I mean, his argument is only thing is that
Yes, ma'am.
how you are prejudiced if I give the certificate now.
the,
Is the now there is a order of the court also,
Yes,
or
ma'am. Yes,
you are doing ad hoc,
ma'am.
whatever.
Yes, ma'am.
Now, if he submits a certificate, how you are going to be prejudiced? Your object is the transportation.
Transportation.
And he is submitting that there is no instance you have cited in your affidavit, saying that no, in similar circumstances, we have rejected another person also. Then if I give it to him, then like if I do not give it to him, then violation of Article 14. And that instance you have not cited here. Now, in this circumstances, how you are prejudiced? And first is that, and secondly, you'll have to answer that whether you'll have to, in fact, answer him that the concept of prejudice
My lord.
will not come in a contract where terms and conditions are specifically laid down
My lord.
and those are there before the parties.
My
Then the
lord.
question of prejudice will not come. Whether that aspect is there or not, that will have to submit on that. Because he's argued on that.
He's argued on that, my lord. My seniors argued on
Mm.
that.
So
lord-
see, I mean, if you are not comfortable, you can argue maybe in the next week also. But you'll have to address on that because he has raised them.
True, my lord.
See, these are some new finer points.
True,
okay?
true, my lord. True.
Yeah, as far as like prejudice is concerned, the principle of prejudice,
My lord.
whether that will be applicable in contracts. Because contracts are typically given.
My lord.
It's a tender document you have framed with your own wisdom.
My lord.
You have given it.
My lord.
Now somebody comes and say that no, how you have laid down certain conditions, right? 1, 2, 3, 4. With your this thing, because you are a businessman, you have your business
Yes, yes,
equipment.
surely.
So accordingly, you have put it that these are the things I want.
Yes, ma'am.
the parties to fulfill.
My lord.
Now somebody doesn't fulfill and comes later on saying that, no, I haven't fulfilled this, but how he is prejudiced with this? Whether that can be argued.
My lord, the aspect of prejudice your lordship had rightly pointed out. Now, my lord, if this contract with the IUCL and the petitioner was a unilateral contract which was concluded, and thereafter, my lord, I opt out or walk out of it, then there is an aspect of prejudice.
No, you submit on the specific point.
My lord,
See, there is an argument made
my lord,
that, fine, he has admitted fairly that, okay, I didn't have that certificate.
my lord.
And one line of argument is that is not mandatory. That is his argument.
That is
correct.
my senior's
And
argument.
second line of argument, he is saying that, see, fine, I didn't have it, but I have it now. How he is prejudiced with this? If I give it to him now,
My lord.
or I have given it in a later date,
True, my lord.
then how he is prejudiced?
True, my lord. True.
So that point, how you are going to address?
The point, my lord, the prejudice aspect here that comes into play, my lord, is that after the LOA, now lordship had furnished an analogy where the petitioner comes and says, I have the registration certificate now, I have fulfilled all the other criteria, so onboard me. Now, my lord, the second line of scrutiny which was done by the IUCL where they had corrected their own mistake, that happened after the LOA was issued. Now, after that defect was clarified, the IUCL entered into, subject to certain ad hoc arrangements, had entered into agreements. Now, my lord, if the petitioner's case is to be made an exception, it would violate Article 14 for all the other bidders who have not approached this honorable court and whose bid has been rejected on the same ground.
That is what I was asking.
My lord.
You have not cited any instance wherein we have stated that I have rejected other bidders also
My lord,
because of this.
We have done this, my lord, at page 212. Not because exactly of this, because that issue has only been raised by my senior.
No, that is true. We are talking about certificate. We are talking about registration certificate, not about now other conditions. There may be thousands of conditions wherein you have disqualified people for different reasons.
My lord.
But you'll have to cite on this.
Then,
Because
my lord,
he's arguing for Article 41 on that aspect only.
True, my lord, true. Since your lordship, if your lordship seeks information on the fact that how many of the bidders have been rejected.
That you have not brought on record.
We have not brought on record, my lord. That is an admitted stand, my lord. If your lordship kindly grants me a short duration, my lord, I'll get the information on that account, because we have done that step for all the other uniform. We have applied the same parameters.
See, I mean, I cannot give you much time, but
No.
maybe till next week.
Next week.
Next week means, next week we'll have to hear it because after that, this court will not be there.
Yeah.
Next Tuesday.
Tuesday.
He wanted to submit before by an email.
Or if email instructions would suffice, because since a short time, my lord, today is a Friday.
That will do, I think.
Let the court know.
I'll be submitting on oath, my lord.
You show us two things. One thing is that like there are, other bidders also. See, Mr. Sharma, that may be or may not be relevant. I don't want to comment on that now. Correct. But we just want to have all the information together to adjudicate it. And couple of arguments that he has made, the prejudice, object. On that point, you assist this court.
We'll do that, my lord.
You assist this court whether the concept of prejudice can be brought in
True, my lord. We'll
in
do
a
that.
contract.
We'll do that.
Hmm?
We'll do that. We'll do that.
And you see that Podda's case object.
Yes, my lord.
Object.
Yes,
He's arguing on this object.
Yes,
So
ma'am.
how your object is being deviated?
Object.
Is your object is not being fulfilled by if he gives it now or he has all other things fulfilled.
My lord.
Only thing is that his certificate is not there. He has new trucks. He's saying.
Yes, he has.
Correct.
In fact, my lord, the arrangement that we have also made have been made with suitable trucks for other. Because, my lord, the reason we have not entered into final concluded contracts is because the honorable court was in session of the matter earlier last year, late last year, and this year.
And you submit on that also. LOA is when you issue an LOA,
My lord,
whether it's a concluded contract or not.
true. We'll do that, my lord.
If
We'll-
3-4 issues, I think you are competent enough to assist this court.
We'll do that, my lord. I'll try my
You
best.
do some homework
Yes,
and come up on Tuesday.
True, my lord.
Hmm?
My lord.
Next Tuesday.
Next Tuesday, my lord.
Yes.
No, I wouldn't have given time to, like some extension of time, but let him
No, that's
assist
true.
this court. He's a young person.
No, he is, I know, he's very good. man.
Let him assist this
He's
court.
very competent. I
Assist
know.
this court. So we'll keep it
You
for
are partnered, my lord, you are the matter on Tuesday.
Tuesday.
Partner, hardened partner.
Heard Mr. D. Das, the learned senior counsel, assisted by C. Garg, Mr. C. Garg, the learned counsel for the petitioner. Also heard Mr. M. Sharma, the learned standing counsel for IOCL. No, sorry, that's one number 226. That's one number 226. The matter remained part heard. Let the matter be listed on next Tuesday, that is on Tuesday will be on 21st. Oh, sorry, 28th. 28th. That we.
Lordship, I'm M. Das appearing on behalf of SK Medi for respondent number 1.
Okay, M. Das for respondent number 1. M. Das on behalf of SK Medi. Turner CGC, CGC for respondent number 1. Okay. It we have to do.
Yes, sir.